All right, we're back on the record on case CR 22211623, State of Idaho versus Chad Daybell. We're continuing jury voir dire in groups today. Is the state ready to proceed?
Yes, Your Honor.
Is the defense ready to proceed?
Yes, Your Honor.
All right, at this time, I'm going to instruct the bailiffs to please bring our next group in. And then I'm going to have a brief sidebar with counsel once the jurors arrive in the courtroom.
That is good. All right, please. Well, here you are.
All right, thank you. Please be seated. All right, good morning, everyone. Before we get started, I am going to have a sidebar with counsel for a few moments. Once we return, then we'll get on the record with or Dyer. Counsel, if I could just meet with you. Thank you. Please be seated. All right, welcome back this morning. We're on the record on case CR 22-21-1623, State of Idaho versus Chad Daybell. We do have a group of jurors returning for group and individual voir dire this morning. The first thing I'll do, just so we are sure who is here and where you're seated, ladies and gentlemen of the jury, if you could just take a moment and hold that red card up and just leave that held up here for a few minutes while we take notes. Okay, thank you. I'll note the states here this morning present with the prosecutors who will be individually announced shortly, the defense as well, and the defendant is here. Before we begin further jury selection, does the state have any objection to the manner in which the panel has been recalled and seated today?
No, Your Honor, thank you.
Any objection from the defense?
No, Your Honor, thank you.
Okay, thank you, counsel. Ladies and gentlemen of the jury, thank you for returning this morning. You've been recalled as prospective jurors in the case now before us. I'll again introduce myself and our staff. I'm Stephen W. Boyce, the District Judge of Fremont County, Idaho, and I'm in charge of the trial in this courtroom today. Our court clerk assisting this morning is Shannon Holstein to my right, and she keeps minutes of these proceedings as well as administers oaths to the jurors. The courtroom deputies are here assisting in maintaining courtroom order and helping you know where you're supposed to be and moving the jury about. Our court reporter, Mary Fox, seated to my left, is taking a stenographic record of everything that's being said during this proceeding, and my staff attorney, Courtney Stallings, is seated to the far right, and she assists me with legal research and administrative issues that come up throughout the day. Each one of you is qualified to serve as a juror of this court, and each of you have filled out a questionnaire that's now been reviewed by the attorneys and the court, and it was determined you'd be recalled for further questioning. The first thing we do in a trial is to select 18 jurors, so we'll have 12 jurors and 6 alternates from among you. At this time, I will have the clerk call the roll call of the jury by using your red card number. So when she mentions your name, please indicate verbally so we have a record that you are present or here. Madam Clerk, would you please take the roll call?
Juror 716? Yes. Juror 722? Here. Juror 732? Here. Juror 751? Here. Juror 776? Can I read your number on?
779, excuse madam.
Juror 834?
Yeah.
Juror 874? Here. Juror 997?
Here.
Juror 1014? Here. Juror 1024?
Here.
Juror 1078? Juror 1093? Present. And juror 1100? Thank you.
All right, thank you. In this group, the court will note upon further review of questionnaires, there were 2 jurors excused. Juror 776, the court reviewed with counsel the questionnaire, and we released that juror based on bias expressed in the questionnaire. Does the state agree that there was a strike there that was confirmed by the court as to juror 776?
Yes, Your Honor, thank you.
Does the defense stipulate also on that strike?
Yes, Your Honor.
Okay, one other juror we addressed was juror 1080. based on a hardship and some bias, was excused or cause. Does the state also make that motion at this time to excuse that juror for bias and hardship?
Yes, Your Honor, thank you.
Does the defense stipulate?
Judge, yes, we do. Thank you.
All right, and the court again has reviewed questionnaires as to both, and finding the information in the questionnaire supports those challenges. Those jurors have been excused. We did have one other juror this morning who will be returning for the afternoon, and that was juror 977. So this time then, addressing the jurors again, to assist you in understanding and participating in the jury selection process, I'll introduce you to the lawyers and briefly summarize what the case is about. When I introduce an individual, please stand and briefly face the jury panel, then retake your seat. This case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution. The state is represented at this trial by Lindsay Blake, Fremont County Prosecutor, Rob Wood, Madison County Prosecutor, Ingrid Beatty, Specially Appointed Prosecutor, and Rocky Wixom, Deputy Fremont County Prosecutor. The defendant in this case is Chad Daybell, and he's represented by his lawyer, Mr. John Pryor.
Good morning, ladies.
This is a criminal case, meaning the defendant is charged by the state of Idaho with a violation of the law. I previously read to you a summary of the charges in the amended indictment when you were here last week to complete your questionnaires. With regard to the defendant, the state of Idaho has alleged that Chad Daybell committed the following crimes. Count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. Count 6, first-degree murder. Count 7, insurance fraud. And count 9, insurance fraud. Mr. Daybell has pled not guilty to the charges. Please remember, this is simply a description of the charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence, you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. The duty of the jury is to determine the facts and then apply the law set forth in the instructions. I will later give to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is, or what the law should be, or what any lawyer may state the law to be. During the course of this trial, including the jury selection process, you are instructed you are not to discuss the case among yourselves or with anyone else, including talking to anyone or use of email, text messaging, social media, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, I'm going to request that our clerk administer an oath to the jury panel for the voir dire examination. Ladies and gentlemen of the jury, if you would all please stand at this time and raise your right hand.
Do you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial, so help you God?
Thank you. The clerk has now impaneled these 13 prospective jurors for questioning in a small group today. Will the attorneys stipulate that the juries were properly called and impaneled, beginning with the state?
Yes, Your Honor, thank you.
That's
Yes, Your Honor, thank
all right. Thank you, counsel.
you.
Court will also note that a juror affirmation has been filled out and signed by all the returning jurors without any issues noted. So these jurors have committed that they have not discussed the case or investigated the case since the time they have filled out their questionnaires last week. In this part of the jury selection, then, you're going to be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of the common law, and in Old French, it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand this questioning is not for the purpose of prying into your personal affairs. Simply, it is for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your red card or your hand. When you're called upon to speak, please make verbal responses to any questions so that we can take a record of what was said, and try to avoid speaking over the top of any attorney questioning you. In addition, I'll note that this proceeding is being broadcast. You are not being filmed or videoed, but your audio is coming through on the court's broadcast, which is being streamed on an official court channel for public access. If you have any answer to a question that you think might be either embarrassing or uncomfortable to discuss in that public setting, please notify us before, and we will be able to discuss those issues with you in a private setting outside of public access. Similarly, if your answer to any question might prejudice other jurors, please refrain from making those kind of comments until we talk to you individually, so that other jurors don't learn information you may already have about the case. This case has also had pretrial media coverage and publicity. So again, we will discuss any knowledge you may have individually and not here in the group setting. I'll now read to you a special instruction for this case as follows. The defendant, Chad Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Vallow Daybell and or Alex Cox. The crime of conspiracy involves an agreement by two or more persons to commit a crime. You must only consider the evidence against the defendant in this case and should not speculate as to any other case or legal proceedings involving the alleged co-conspirators. You must remember that the defendant has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. That concludes the court's special instruction. At this time, I'll also instruct the attorneys to please avoid repeating any questions already asked by the court. However, you do have the right to direct follow-up questions to a juror regarding that juror's response to previous questions. The jury should be aware that during and following the voir dire examination, one or more of you may be challenged. Each side has challenges called for cause, by which I mean that each side can ask that a juror be excused for a specific reason. In addition, each side has a certain number of peremptory challenges, by which I mean each side can challenge a juror and ask that he or she be excused without giving a reason for the dismissal. If you are excused by either side, please do not feel offended or feel that your integrity or your honesty has been questioned, because it is not. I'll also advise you, if you are excused from jury service after a challenge, then you may be approached to discuss this case. You are permitted to do that. However, I would ask you to be mindful of your fellow jurors and the fact that this court is trying to find impartial jurors in this case. And if you don't want to talk to someone about the case, you don't have to. And if someone persists in trying to talk to you, please report that to the court. At this time, then, I will begin the court's portion of the voir dire process, after which I'll allow attorneys for both the state and the defense to make their own voir dire inquiries. If we are discussing questions with any given juror, please pay attention to the questions and answers, as you may be called upon later to answer those same questions. The first question I'll ask is not in relation to the long questionnaire you filled out last week, but just your juror information form, which has information such as your residence in Ada County. I'll ask each one of the jurors now as a group, are the answers given by you in that juror information form still true and accurate? If so, please raise your red cards. All right, thank you. It appears all the jurors still have accurate juror information forms. The next question I'll go to is on your jury questionnaire. And those were last week, they were lengthy. Is there anything in there that you think needs to be corrected or clarified at this time that we wouldn't just discuss with you individually? All right, nobody appears to have any correction at the outset to the questionnaires. The next topic I want to discuss then involves the length of this trial. This will be a long trial. We're estimating a time frame of 8 to 10 weeks. I'd like to know if any of you believe serving for that much time would create a serious hardship upon you or your family, or your business or profession or occupation, to prevent you from rendering service as a fair and impartial juror in this case. So if you believe you have a hardship based on this time commitment, please raise your red card at this time. All right, we've got 3 on the back row. All right, we're going to take these up individually at this time now. So first juror we'll talk to about that will be juror number 834. All right, juror 834, you did talk about in your questionnaire concerns as to whether or not you would lose income and employment during this case. Can you explain what that hardship would be if you were required to serve? And you can remain seated if you wish.
Thank you very much. I'm a field service staff 71 that's supporting all the send out sponsors. And that would be conflict so much of my work because I don't have anybody right now. So I'm touring hospital from Boise to the city. So I don't know, so that would be difficult for me if I had to be injured for up to 10 weeks.
Have you been able to discuss with your employer the possibility that you might be required to serve on this jury?
I did.
And did they advise you anything about whether or not they could accommodate your service or provide pay if you were serving?
I just notified them because I didn't know I could be before, because I just told them to stand by, so I haven't discussed after this.
All right, is this employment your sole source of income?
Yes.
All right, let me inquire, well, have the state asking voir dire on the issue of hardship, and then I'll allow the defense as well.
Your Honor, the state actually had it marked to discuss hardship with juror 834. I had noted that he had listed that in the questionnaire. I think we've been provided more information today regarding whether or not there's ability to provide coverage for him. Given everything that was in the questionnaire and indicated today on the record, the state would make a motion to remove this juror for cause based on hardship.
Response from the defense.
Judge, I also reviewed the facts, and I would also move to excuse this juror for hardship.
All right, based on that, the court's also reviewed the information in the questionnaire, finding that for this particular juror, service of that time frame would create a serious hardship financially for the juror and his family. And so for that reason, juror number 834, you'll be excused with the thanks of the court. Thank you for filling out your questionnaire last week and coming back. I'll have you drop a copy or your questionnaire with the bailiff, and then you're excused from jury service. Let's next talk to juror number 874. You stated in your questionnaire you thought the financial strain would create a distraction for you if you were required to serve for that much time. Can you explain that a little more?
I would be going without income for all that 1 week of the trial, and that would create financial hardship.
Have you talked to your employer about the possibility that you'd be serving for this case?
Yeah.
And did they indicate any policy of allowing for service or pay during your jury service?
They would allow the service, but there would be no additional.
All right, and I may be confused there. So they're not paying you income. In other words, they'll hold your job but not pay you while you're here. All right. Did they have any time frame they could pay you that you're aware of?
For 40 hours, so then
Okay. And is that your sole source of income?
yes.
Any questions for this juror on the hardship issue?
No, Your Honor. Similarly, we had it marked to follow up with this juror regarding the indication for potential hardship in the questionnaire. Given that additional information, the state would make a motion to remove this juror for cause based on hardship.
Response from the defense.
Judge, I'd also concur on the state's motion of hardship. It has to excuse this juror.
All right, juror 874, given your explanation here today and the length of this trial, you'll also be permitted to be excused from your jury service for the expression of the hardship. And so the court thanks you for filling out your questionnaire and taking the time to come back today. Please drop that off with the bailiff and you can be excused. Juror number 1014.
I was looking to often things would be
Sorry.
Oh, sorry. I'm working 2 jobs and I'm in school full time, and so doing a 10-week trial would be very difficult for me to meet deadlines for in college. And then also for one of my jobs, I would be able to have a fund set aside, but for one of them I do not.
All right, are you currently in a semester in school then?
Yes.
And are you full-time or part-time student? All right, if this trial were taking up pretty much all of your time and energy, if you were serving with that for that length of time, would you end up losing the semester basically, do you think?
I would think so. It's pretty busy semester.
And when does the semester end?
It ends in April, the very end of April.
Questions on voir from the state, please.
Your Honor, similarly, we had it marked to follow up with juror 1014 based on some indication of a potential hardship. And given all the additional information today, as well as what was stated in the questionnaire, the state would make a motion to remove this juror for cause based on hardship.
All right, response from the defense.
Judge, I would also concur in that motion to excuse this juror.
All right, juror number 1014, the court has considered the motion to strike as well as the information contained in your questionnaire and your responses today. And I do find that service for that length of time would create a serious hardship upon you. So for that reason, you'll be excused with the thanks of the court also. So please drop your questionnaire with the bailiff, and we'll give you instructions. All right, did we have another card raised by 1024? All right, juror 1024, you raised your card as well and mentioned something in your questionnaire about a trip coming up in late May. Could you explain that, please?
Correct, yeah, I have a family trip that my parents have been planning for a while. It starts May 25th, and we've already booked plane fare and hotels. And so, yeah, certainly, if it ran into that, that would be a problem. It's, you know, my kids are going, my wife and my parents. So,
All right, if we did go into that time frame then, and we were coming up near that, do you think that would start creating a distraction for you and paying attention to the case here?
I mean, certainly it would be a challenge. I mean, it's a pre-planned trip. I mean, if the trial happens before that, that's fine. I don't have any financial hardship otherwise than that. So my income isn't dependent on a specific job that I show up to. It's dependent on some investment. So, yeah, it's just the trip itself. So it's, I haven't honestly looked to see, I mean, rescheduling it would be rather challenging. So, that would be the main issue. So, I mean, certainly if the trial is less end before that, then that's fine. But
All right, I'll have the state inquire.
Your Honor, this is also a juror that the state had marked to follow up with, given what was indicated in the questionnaire regarding that trip. It sounds like where that trip is planned and the current estimation of time on this trial, I think the state would make a motion to allow this juror to be removed for hardship.
Response from the defense?
Judge, may I have permission to go matter?
You may.
Sir, I noticed that you have a couple of kids, if I remember right, 10 and 12. Is that
I have, 11 and 12-year-olds. Yes, correct.
11 and 12? Sorry.
Yeah, so it's a trip at basically the end of school, right?
Right, it's a family trip that involves the grandparents as well.
Yes, yeah.
Okay, and if you were fulfilling your obligation to be on a jury at that time, would it be safe to say that you would probably be distracted by your children and everybody else on the trip while you were trying to go through this process, and maybe would be anxious to move this process along while you're thinking about them while they're on that trip?
I mean, certainly if they went on the trip and I was still here, that would be, I mean, my kids are fairly independent, but it would, I mean, any parent would be nervous about their children traveling, but I mean, my wife would be on the trip with my parents. So, I mean, certainly they're not gonna not go because I can't go.
Right.
But yeah, I mean, certainly before the trip, that's fine, but it's just during the trip.
Well, I guess
That would be a challenge because, just making sure, I mean, they're going to Boston, and so, just all the logistics of moving two children around a large city.
Well, I guess I was really concerned about the emotional impact that it might have on you, the fact that this is a long scheduled family trip with extended family and celebration of your kids getting done with school, and I read about that. And I guess what I'm concerned about is that potentially this could be a significant distraction. That's what I'm concerned
A significant distraction before
about. If you were to go here, and the indications, at least what I'm getting, is that there's a likelihood that children may go on this trip, and you're going to be, if the case goes until the 25th, I think that could be a distraction. That's what I am concerned about as well.
Yeah, I mean, I understand your question, and I would say up until the point of the trip, as long as the trial ends before that, it's not an issue for me. It's just if the kids went on the trip. So yeah, that's the only issue. I mean, if the trial ends before that, that's fine. I mean, it's not a problem. So it's just, yeah, if the kids going on the trip and me not being there, with it being a busy city, and then, them having to navigate with my wife and grandparents, as you would imagine any father, would be concerned. I mean, it's pretty common. So,
And Judge, based on the responses, at this point, I'm going to move for cause as well and Ask that the court excuse this juror.
All right, the parties have both made the challenge for cause for an express hardship. The court will grant the challenge and juror 1024 is excused. Thank you.
Thank you.
Okay, thank you, ladies and gentlemen, who are remaining here and have expressed a willingness to commit this extensive time for your service.
Your Honor, I'm sorry, but may I as well?
Very well. Juror 1093.
I am the primary provider, caregiver for two young children, 6 and 8, and they homeschool. At the beginning of this, the time frame was stated at 8 weeks, and I assumed it would be starting a little sooner. There is definitely the ability for me to put my kids into public school to cover that. But as time has gone on, and with the possibility for this trial to be longer, 10 weeks or more, if that should happen, it would definitely be a difficulty for us for childcare, as I take care of the kids and the farm, and we're out when
All right, and when you say the farm, could you just describe a little bit more about what responsibilities you would have there at your homestead?
Sure. We have 5 acres and we raise sheep and chickens. Lambing is coming up soon. We're gonna have baby lambs, and we grow a lot of our own food and raise meat birds.
Okay, and there is a potential of this case going into the time frame you were discussing, so let me get some additional voir dire input from the state.
Your Honor, I think given that information, the state does not have any additional questions. With all of that going on and the described hardship, the state would make a motion to remove this juror for cause based on hardship.
Mr. Pryor.
Judge, I would agree with the state. Ask that she be excused for hardship.
All right, reviewed your questionnaire, juror 1093, also looked at makeup of your family and what you've got going on with your children as well. And so for those reasons stated and what you've indicated on the record today will allow you to be excused for your hardship request. Or does find that it would constitute a hardship for you to serve for that time period. So thank you for taking the time to complete your questionnaire and coming back today. You can be dismissed.
Thank you, Your Honor.
Okay, for the remaining jurors, then we're gonna shift topics to something else. The next issue is whether or not you have any knowledge of this case from previous media coverage or otherwise. You've heard a summary of the charges that are contained in the amended indictment. Other than what you've learned here so far in the court proceedings, do you know anything about the case? And if you do, please raise your red card. All right, and we've got several, if you'll hold those up for a minute, we are going to talk to you individually about your knowledge of the case a little later this morning. So I won't ask you any details about what you know. We'll talk to you about that one by one. And 751 also. Thank you. Let me next address the subject matter of the charges here. In this case, you've heard what the charges are, but that subject matter of this case involving charges of murder, conspiracy, and insurance fraud make it difficult or impossible for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict. All right, no one answered affirmatively. I'll next ask a series of questions that seem like they should be very obvious if we looked at your questionnaires, which we did, but I'm required to go through these on the record to satisfy certain statutory requirements, making sure you don't have any connections to parties involved in the case or the defendant. So with that in mind, first question on that topic is, are any of you related by blood or marriage to the defendant, Mr. Daybell, or do you know him from any kind of business or social relationship? No one answered yes. Do any of you have a legal relationship of some kind with any of the attorneys in this case, such as guardian and ward, master and servant, employer and employee, creditor, debtor, landlord and tenant, boarder, or lodger? No one answered yes. Are any of you a party in any civil action or lawsuit against the defendant? No one said yes. Have any of you ever brought a criminal complaint against the defendant, Mr. Daybell, or have you been accused by any of the prosecutors here today of any crime? Okay, no one answered yes there. Do any of you have any attorney-client relationship, either now or in the past, with Mr. Pryor or his law firm? No, and just to be clear, that's the defendant's attorney again. No one answered yes. Are any of you related by blood or marriage to any of the lawyers in this case, or do you know any of them from any kind of professional, business, or social relationship? No one answered yes to that. Have any of you ever formed or expressed an unqualified opinion that the defendant is guilty or not guilty of the offense charged? No one answered yes to that. Do any of you have any type of bias or prejudice either for or against the defendant, Mr. Daybell? No one answered yes. Is there anyone here that is unwilling to follow my instructions to you as the jury as to the law that you must apply in determining the case? No one said yes to that. Do any of you have a religious or moral position that would make it impossible for you to sit in judgment of another or to render a fair and impartial verdict? All right, no one answered yes to that. Are there any of you that if you were a juror on this case would be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in the courtroom and the law instructed by the court? All right, no one said yes. A final question then. Do any of you have any other reason why you believe you would not be able to give this case your undivided attention and render a fair and impartial verdict? All right, no one answered yes to that. So that concludes the court's section of voir dire. I'll next allow the state to commence with its voir dire, and after that, the defense may do so as well. Who's going to be conducting voir dire of this panel this morning?
I will be, Your Honor. Thank you.
All right, Ms. Flake, if you'd like to commence, you may.
Ladies and gentlemen, thanks for being here with us this morning. I know this process has already been somewhat lengthy. You were all here last week and you filled out a questionnaire, and now we brought you back this week. So I want to thank you for sticking with us through this process. As we go through this, and just to kind of let you know a little bit about what we're doing here, is we're trying to ensure that we go through an extensive process to make sure that we get jurors that truly feel that they can sit on a jury in this matter and provide a fair and impartial verdict, and that they feel that they can see that duty through. Because there's a few reasons for that. The defendant, Chad Daybell, deserves a fair trial, and so does the state of Idaho. So that's why we go through this process, to just make sure that we get there. If I use the term brutal honesty, I'm going to ask juror 1100, what comes to mind if I use the term brutally honest, if someone wants someone else to be brutally honest?
I think for me, brutally honest means that you have to be truthful in all aspects, that you need to be not hiding any of the pieces, that you, as difficult as it may be, you need to be able to articulate what occurs. go brutally on.
Thank you. I appreciate that response. And juror 751, how about you?
Can't find other things.
And would everyone agree that it could also include not worrying if you're hurting someone else's feelings? That you just, it can't be a little white lie, it's just gotta be, it's what it is. Thank you for that. And the reason I bring that up is there's a couple things with that. So today, obviously, I'm asking you questions. I don't want to make anyone uncomfortable or put you on the spot, but we're just going through this process. And as we go through it, we want everyone to be brutally honest with us. If there's something you think we should know, tell it to us straight today. And the second part is, if you're selected to be on this jury, you're going to be given instructions by the judge. And when it's time, he would let you know that you could begin discussing things with the other jurors. And we want to make sure that everyone feels that they can be brutally honest, that they can be truthful with everyone as they're going through the process. So could everyone today commit that they can be brutally honest as we go through this? I see everyone shaking their heads in some audibles. Thank you so much for that. And one other thing I'll mention, the judge also mentioned this, but as we go through this process, if at any point there's something that you want to discuss without everyone present, let us know and we can work with the court to make those arrangements. I recognize sometimes there's sensitive subjects and they may be things that I don't even realize are sensitive. So I want to make sure everyone knows that. We want to be respectful as we go through this. Has everyone here been on a plane before? Everyone's nodding yes. When you get on a plane, usually at some point you get an announcement over the PA system. You know, sit back, enjoy your flight. We're going to take off. We'll arrive at the destination at approximately such and such time, and they take off. If instead of hearing something like that, you got on the plane and the pilot told you, I'm going to try to land the plane. I think we'll be there at this time. How many of you would feel comfortable on that plane? I'm seeing people shake their heads no. And can I ask juror 779, would you want to stay on that plane? Why not?
Because I would fear for my life, because I know the pilot was not experienced if he said something like that.
And juror 1078, how about you?
I agree. I would definitely not feel assured, hearing an announcement.
Thank you. And the reason I ask that is because we're basically going to ask you all to be the pilot with this case. So again, we talk about it, but the judge will give you instructions, and at some point it will be up to you to make a decision in this case and render a verdict that you believe is the correct verdict. And does everyone here feel that they could do that they could sit on this jury and at the end of it, listen to all the evidence, give it the weight you think it's due, deliberate, and ultimately render a verdict that you felt was the best verdict? Thank you for that. So the other part of this, and the judge has gone over what the charges are in this case, and we have several counts of conspiracy to commit first-degree murder, and we also have several counts of first-degree murder. The victims in this case involve 2 minor children and a mother of 5. As we go through this, the state has the burden of proof, and as part of that, we present evidence. Some of the evidence may include some photos that are unpleasant. They may be graphic autopsy photos of children or that mother. Does anyone, as they sit here today, have concerns that if they were to see graphic images like that that are unpleasant, that it would cause you concerns about your ability to still sit on this jury? And juror 722, I think you have children. I believe they're adult children.
Yes.
Being a mother, does that cause you any concern, or do you feel you'd be able to look at those images and provide them the way you think they're due?
I think that's a fair question, because you see things on TV and it's kind of like more hypothetical, but I believe I can. I believe it's significant enough of a thing that I will be able to confront.
And do you feel like even if they maybe elicited a reaction from you, that you would still be able to weigh them fairly in light of the other evidence?
I would.
Thank you. And juror 732, I'll ask you as well. I think you also have children, adult children. Same question, does that cause you any concern?
It causes me no concern for my impartiality. It causes me concern for sleep and mental health. But it does not cause me concern.
Thank you. And just to follow up on that, because it's normal to be disturbed by these. It's normal to have whatever reaction we have as a human to images that are unpleasant. But anything about maybe having an emotional reaction or losing some sleep that would make you think you would, for any reason, give them more weight. Thank you for that. So I have a young kid, and when we get up in the mornings, if I ask him what he wants for breakfast, 9 times out of 10, it's cheesy eggs. But there's a very specific recipe that he likes me to follow, and it's simple, but it's what he likes. So it's the eggs and the milk and the cheese and the salt and pepper. And if I don't follow that recipe, sometimes he's not very happy with me. And sometimes I might modify it because maybe he wants a little bit of extra cheese in it. Can others relate with having someone, whether it's a kid or someone else that maybe has a very specific recipe or a very specific way they like things done? And juror 716, I see you nodding along. Have you had a similar experience?
Yes, I have. I mean, I have 2 kids, so, or 3 kids. One lives with me still, and yeah, it's yeah, I've been in that situation.
And do you end up a lot of times just following what that kid may want?
Sometimes, I wouldn't say all the time.
Do you sometimes modify it?
Yes.
And juror 722, I saw you also nodding. Is it similar for you?
Yeah, just, or I remember the 2-year-olds and 3-year-olds, you know, they think they know what they want, and then of course you do it, and then they change their mind, and somehow you cut it wrong.
Yeah. Yes. I have been there as well. So with that, so we all kind of have recipes that we follow for certain things, and sometimes we might tweak them in our everyday lives. Maybe a kid wants something done a little bit different. Maybe we think we can make it better. But in this case, the judge is going to give us all, or you all, jury instructions. And those jury instructions will include an instruction on the elements of each crime that the state has to prove. And kind of like ingredients, they're going to be listed out. And unlike real life, where we might say, I might tweak this a little bit, or I might add this or take this away, you're not going to be able to do that. Whatever the judge gives you as the instruction, that's it. Does anyone have concerns that if you look at that and you think, oh man, I don't like this element, or why don't they have to prove this too? Could everyone commit that they'll just follow what's given by the judge? Does anyone have concerns about that? Thank you. With some of these charges, with the murder charges, there's going to be elements listed out in those instructions given by the court. And with regard to homicide, it's going to say the defendant engaged in conduct which caused the death of a person. There is not going to be an element on there that says the state has to prove the cause of death. So essentially, the state has to prove they did it, there was a murder, but we don't have to prove how the person actually died, what the actual cause was. Does that cause anyone concerns, or would you be able to follow the instructions as given by the court? It's like people are nodding along, but they could follow the instruction. Thank you. Do we have anyone here that's an NFL fan? I see one hand. Some people kind of say maybe. Juror 997, you're an NFL fan?
Yes.
I think Kansas City Chiefs won this year.
Good.
And you may or may not be happy about the outcome.
We'll talk later.
Yeah, I won't make you publicly disclose. I know some people hold those things very dear. But regardless of your feelings on it, do you feel that every person on the Kansas City Chiefs deserves to get a Super Bowl ring if they were part of the team?
Absolutely.
And with that, so even if the quarterback maybe played a bigger role, should the second string players also get a ring?
Yeah.
Coaches?
You bet.
And why should they all get a ring in your opinion?
Because they all participate. It's a team effort.
Thank you. And juror 751, I'll ask you the same thing. Do you think they should all get a ring?
Yes.
And what's your reasoning behind it?
They work together, they build their together. Just make one person can follow.
Thank you. The judge already gave you an instruction today, and he'll give you a lot more instructions as we go through it. The instruction today dealt a little bit with conspiracy. And the judge has already said conspiracy includes an agreement by 2 or more persons to commit a crime. He also instructed you that you would not consider the co-conspirators what may or may not be going on with any cases with them or their guilt or innocence with regard to this trial. So with regard to Rory Daybell and Alex Cox, you wouldn't consider those things. However, in this trial, you will hear evidence regarding actions alleged to have been taken by those two. And as I said, the conspiracy itself, an agreement by 2 or more persons to commit a crime. And then again, the judge will give you the specific instructions, but it also includes that then only one person has to, but any one person that's part of that agreement takes one act in furtherance of it. So just one overt act, one act to try to commit the crime that they all intend to commit. All of them don't have to do an act. Does anyone have concerns here today that if person A and B or A, B, and C agree to commit a crime and only person B does an additional act, does anyone have concerns still holding person A and C accountable? If you believe the state proved there was an agreement that they intended to commit a crime. Does that cause anyone concerns? Thank you. So, and today it did actually rain, but let's say that as you were on your way here today, the sky was just gray. It was starting to turn gray. You came here in the courtroom, they closed the blinds, you couldn't see outside, and you go outside after court and there's water all over. So water on your car, water on the grass, water on the pavement. You start driving home, everything's wet. You see a rainbow in the sky. Would you be able to determine what had happened? And juror 732, what would you determine had happened?
Rain, or moisture, snow, rain.
Something had happened, some kind of precipitation, moisture had come from the sky. And juror 1100, how about you?
Yeah.
And you would be able to make that determination without ever having seen it rain. So in the trial, you may see different types of evidence, and you may hear the term circumstantial evidence. Does anyone here have concerns considering all the evidence presented and weighing it and not worrying about what type of evidence it is, whether it's circumstantial or other? Does anyone here have, because knowing the nature of the charges, does anyone have in their mind a specific type of evidence that you think the state would have to show or that you would expect us to show in this case? I don't see anyone saying yes. And again, just can everyone commit that you would follow any instructions as given by the court? And would everyone agree that even if someone tried to convince you or try to tell you that the instruction was different than it was, would everyone commit you'll only follow what the judge tells you? Thank you so much for your time today. I really appreciate it.
Judge, could we approach from that?
Yes. Jurors return to the courtroom. Yes.
All right, please. Council President.
Thank you. Please be seated. We're back on the record on CR 22-21-1623 State versus Chad Daybell. The state just concluded its voir dire examination of the group. Mr. Pryor, if you'd like to commence with the defense, you may.
Judge, I may approach the podium.
Yes.
Good morning, ladies and gentlemen. My name is John Pryor. I introduced myself to you folks earlier, and I represent Mr. Daybell. The reason we're here today is because Mr. Daybell has stated to the court and now to all of you that he's entered a plea of not guilty. The part of this voir dire, the French word that the judge used, is really an opportunity for all of us to get to know each other a little bit. Would everybody agree that we all have different experiences in our lives? We all have different biases. Some of us have job biases. Some of us have occupational biases. We try not to do this, but some of us have religious bias towards certain people, and that can be problematic as well. But what we are trying to do is get to meet you folks, trying to understand what your opinions are, how you feel about a variety of issues, and Ms. Blake did a very nice job of talking to you a little bit about that with some of the discussion about cheesy eggs and I think airplanes. And I'm going to talk to you about a few things as well. But before we start, I think Ms. Blake talked about this a little bit as well. It's really important that you speak your mind. It's really important that you say how you feel about an issue, because quite frankly, I probably have 10 or 15 minutes to get to know you folks and decide. Both of us are trying to say, okay, these jurors are the folks based on their experience, all of the things in their life are the ones who would really be the best jurors to give us a fair trial. And that's really what we're trying to do, have a fair trial. So I'm going to ask you a couple of questions, and I don't want you to think that these questions are designed to suggest that Chad is guilty. I have to ask you the questions because I have to delve into this. And again, if there's anything that you don't like or anything that you feel uncomfortable about, just stop and say, John, hold off. We're going to talk to the judge privately, and I don't want this. I don't want to talk about this in a more private setting. Is everybody okay with that? Okay, thank you. So I'm going to go down a couple of the questions, and I'll cover some other items, but just basically, when you heard the charges read, did anybody just assume, well, he must be guilty because of the charges? Raise your cards if you think that. Okay. Does anybody believe that Chad has to testify in this case? Does anybody believe that Chad has to testify and prove to you folks that he's innocent? Do all of you folks understand that Chad doesn't have to put on one bit of evidence? Does everybody agree with that? Just pop your hands up or cards, whatever you're comfortable with. Everybody understands that. And if Chad doesn't put on any bit of evidence, you can't hold that against him. Does everybody understand that? Thank you. Thank you. I want to talk to you a little bit about the media and your opinions on the media. Would everybody agree that the media has a tendency to maybe inflame things? Raise your hand if you think the media has a tendency to sensationalize or inflame things. All of you agree with that. Does anybody believe for a second that you get the whole story from what you hear in the media? Would you raise your hands just so I can see? And I guess I'd like to talk, I think what I'll do is I'll start with 1078. Talk to me a little bit about what your view is of the media's role in a case like this.
I guess the media definitely uses it as a story, not so much fact-based. So yeah.
Okay, and we'll go over to juror 997. What is your thoughts on the media?
I try to avoid it as much as possible,
Okay,
because I agree whether it's local or national. I don't think you're getting all the specifics or all the facts. There's a reason why I think the media chooses stories, whether it's for clicks, whether it's for viewers, whether it's for attention, whether it's to get their name out there to the population.
okay,
Yeah.
okay. And you said clicks and attention, and quite frankly, a lot of it is the greater the sensationalism and the more viewers, what does it really come down to? Right?
Absolutely.
Comes down to money, right? So when the media is sensationalizing and calling somebody a name and making a suggestion or stirring something up, really, they're hoping everybody watches what they have to say. They're hoping that this is a way for them to gain, readership. And the bottom line is it's all about money. 779, you're shaking your head, you're acknowledging it. Do you have any thoughts on this?
I mean, I think it's kind of been explained, and I agree with what the pastors have said. A lot of the time, I think journalists try to make a story, not always make it as factual, or if it is factual, maybe not leave in all of the facts, just try to make a story for people that catch their attention.
And would everybody agree that we shouldn't convict or judge somebody based on all of these outside influences? Would everybody agree with that? Okay. And I want to talk to you a little bit about some terms. Okay. Now, the judge already instructed you that the case is about facts and evidence. Okay. Facts, evidence. Does everybody understand what I mean by facts and evidence? Is there anybody who doesn't understand? The car is red. The car was seen not stopping at the stop sign. Fact, evidence, okay? Is it fair to judge anything by other than fact and evidence if you're making a major decision in any regard? Okay, and I'm going to go to juror 751 because you're the first and you really shook your head strongly. So talk to me a little bit about facts and evidence.
Rule can be very black and white. They're also gray. You're asking us to disregard gray. The court's asking us to look at what's presented and what's evidence and to weigh that against the top of what's told.
And you have a wonderful voice, but you said something that's very important. The court is asking us to consider the facts and the evidence. That's it, right? Does everybody agree with that? Facts and evidence? 722. Is it about facts and evidence?
Yes.
Okay. So, and I'm not going to pick on Ms. Blake, but I want to use her example because it's important. It's important because if we're looking at making a major decision and we're trying to guess whether that plane's going to crash or not, and we have to make a major decision, should we be basing it on speculation? Ever? Should you be guessing about what facts may be? Ever? Does everybody understand what the term conjecture means? It's a big word. And I try to avoid big words. Does anybody not know what conjecture means? Okay. Would everybody agree that speculation, conjecture, and guessing are pretty much the same words? Is there anybody who would disagree with that? Okay. We all have to make major decisions in our lives, very serious decisions. Things that can affect us long term. Serious decisions, and all of us have had to make, I would assume all of us have had to make those serious decisions. When we're looking to make major decisions, it's important to look at the facts. Would everybody agree with that? Would everybody agree that we should not engage in conjecture or speculation or guessing? Now, this judge read us an instruction. And aside from anything else, more than anything else, we listen to him. I will listen to him. I promise you I will listen to him. And the court, and I'm going to commit you and ask you to commit to listen to him as well. And the prosecutors will listen to him. And when Judge Boyce gave you that special instruction, he talked about not taking anything on the outside and looking at those outside influences, okay? And what I'm looking to see if what you folks could do is commit to something. And commit that we're not going to look at what the media people say. Can everybody commit to that? We're not going to commit to conjecture, speculation, and guess. Everybody commit to that? And we're going to commit to looking at just the evidence that's presented during the trial and the facts that are presented in the trial when we make a decision. Can everybody commit to that? And I want to thank you for that, folks. Thank you. A couple of other things. I listen to a wide variety of music. Because at my age, I've had a chance to be exposed to everything from, I've been exposed to, oh my gosh, it's embarrassing, the 70s and the disco age. And I promise you I didn't wear the bell-bottom pants, but I was exposed to it. And I've been exposed to the movie music from the 80s and the 90s. And my children, I don't understand the stuff that they're listening to, and I can't even understand the words. I don't get it. But I do listen to a little bit of country music now. I find it very relaxing for me. And there's a song out there that the title of the song is "Everything That Glitters Is Not Gold." Okay, and 716, you had an acknowledgement and you smiled. So talk to me about what you think that means.
Some things look really nice on the outside, but once you get on the inside, be it a person, be it a piece of equipment, be it whatever, it may not be the same as what you're seeing.
Right, and sometimes you get into it and you see this gold glitter, and it could be, like you said, it could be a job, where someone has a job and they make the job sound absolutely wonderful. And then suddenly you get in the job and you find out, oh my gosh, it's too late. I'm in this situation. I don't really know what I got involved in. And you're blinded. And can people be blinded by the glitter? Is there anybody who believes that you can't be blinded by the glitter? Okay. Many, many years ago, I was reading a story, okay? And I'm guilty as well. Sometimes I read their stuff as well. I like juror number 977, I try to avoid it. But I read a story about a 92-year-old millionaire, and he married an 18-year-old woman. And I think that's a big age gap, okay? Yeah. Juror 779, you're shaking your head, okay? 74-year age difference. Is that an example of, looking at the glitter and maybe not thinking it's gold?
Oh, yeah, 100%.
Okay, yeah. Juror number 1078. Is that a case of looking at the glitter and not realizing that there's no gold there?
Yeah, I would think so.
Okay. So sometimes you get into these positions and maybe you're fooled Or maybe you're tricked. Or maybe you're convinced of something and it all sounds really great. And I don't want to just talk about relationships, I want to talk in general. And you could be convinced to say things, to do things, to act a certain way, and be drawn into something. Do people agree that that's something that in real life, those sort of things happen? I haven't spoken to 732, and you didn't give me a big nod, so I guess I'd like to see if you can talk about that. Don't want to talk, if you don't want to talk about it, it's okay.
You had a lot of words in there, but I'm not sure I completely understand exactly what your question was, or the
Okay.
amount of verbiage that was used.
Okay.
Would you clarify that?
Well, let me ask you this. Do you have any difficulties with the idea of my song, everything that glitters is not gold?
You don't live to be this age and have grown kids and not experience that in some
Right, in some,
way, shape, or form.
in some capacity. Okay, thank you. And again, when you're looking at an important decision in your life and making a big decision in your life, is it a checklist of things you go off to make a big decision? Do you just say A to B, B to C, C to D, E to F? Or are there emotional factors and other factors that you need to consider? It's not just black and white when you're making huge decisions. First, there's personal and emotional considerations that you need to make when you make a decision. Everybody agree with that? Okay. And everybody again would agree that when you're making a decision, and should you be on the jury, you're committing to applying facts and evidence, and that you will not speculate about anything. Is that fair? I'm going to talk to you about one more topic, and I will leave this to the end, okay? And I want to talk about graphic photos. And you're going to see graphic photos. And these graphic photos are going to hurt your hearts. In this case, these graphic photos hurt my heart. Okay. I want to ask you folks, is it fair to look at graphic photos and because it's upsetting to you, that anger or emotion or whatever emotion you feel should be taken out on Chad? Does anybody agree that when you look at graphic photos, you should immediately take it out and blame him for those graphic photos? Again, you should look at, and as an example, I think it was juror 1078. It may have been 997. One of you spoke about that there's images and photos showing, and media does this to sensationalize and try to draw. I guess it was 1078. You're nodding your head. The media shows graphic photos or images to gain a reaction from you, to sort of steer you in how they want you to feel or think, right? The concern is this, is that if you're shown these graphic photos that hurt your heart, is it fair to immediately put the cause and the blame on Mr. Daybell just because the photos are graphic? Everybody agree? Do you all agree with that? Because again, what we're doing is we're looking at facts and evidence. We have to consider the facts and evidence. And again, everybody commits to that, right? All right. I want to thank you folks. I know this isn't easy. I know that's very difficult, and both parties need to have time to be able to spend with you and get to know your views on things. And I want to thank you for spending the time with me, and I appreciate that very much. Thank you, folks. Judge, that's all I have, though.
All right, thank you, Mr. Pryor. This When in the proceedings, then we're going to take up individual or dire of this remaining group. We'll go lowest number to highest, so starting with juror 716. So if all would please rise for the other jurors to be excused, and 716 can remain. Thank you. Please be seated. All right, thank you for returning again this morning, juror 716. We're going to conduct some individual questioning of you at this point, as well as all the other jurors that remain. I didn't see any information in the questionnaire about concerns of prior case knowledge, nor did this juror indicate they had anyone asked. So there is some indication that you may suffer hardship if you're required to serve for this time. I don't think you pointed that out again this morning, but there are some questions about that in your questionnaire. So if the state wants to conduct any additional voir dire on hardship, we can start there, and then I'll see if the defense has any questions following that.
Thank you, we do, Your Honor. So I do just have a few questions about sort of comments. Oh, okay, sorry about that. So do you happen to have your questionnaire with you? Okay. Might invite you to go to pages 20 and 21. And I would just call your attention on page 20 under the question number 1 in trial length. It indicated I work 3 days a week. I would have to arrange this with my boss to find a workaround for my work during this time. I was only project manager. Can you explain what did you mean by that? And is it still a concern that it could potentially impair your ability to serve on the jury?
I work for a very small construction company, and I manage construction projects. I did talk to my supervisor, who was actually the owner of the company, and he said he could fill in for 6 to 10 weeks, however long that his trial would be, he could fill in that role of project manager. So that's no longer.
Okay, okay. So then you don't feel like you would impair your ability to serve. Okay. Now let's go down to one more comment. You did also indicated that you'd lose pay for 6 weeks. Is that still accurate, or is your employer going to help compensate?
We don't talk to him about that. He's very generous. I'm guessing that he will, but I also get a pension. So I have another.
So then, as you said, you're not concerned about loss of pay if you're a juror. Okay, thank you. Anything else that you need to discuss about potential hardship, or are you comfortable? No, I don't have any more questions.
Judge, I don't have any questions on bias or hardship.
Okay, thank you. What we'll do next then is go through a different topic that's included in your questionnaire, juror 716. If you have a copy there, please turn yours to page 12. In the questionnaire, we asked you about your attitudes regarding the death penalty. And do you recall thinking about those questions and putting these responses in the questionnaire? And as you sit here today, do you still feel the same way in terms of how you answered those questions?
Yes.
All right, I do want to notify you in this case, when you're filling out the questionnaire, perhaps you're thinking hypothetically, but here in the case, it may actually be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you're considering should be done as if it would be absolute and carried out in the case. So with that in mind, I'll just have a few questions for you about your responses. You first indicated on page 12 in the option of supporting or opposing the death penalty, you said you support. Is that still the way you feel today?
You support it, depending on, you know, the case evidence, if it's proven, and that should be the crime, the punishment for that crime, yes, we support it.
Okay. If you turn one more page then to page 13.
Okay.
On that page, we gave you a choice of 7 different options that for you to select what most accurately represents the way you feel. And I assume you read through each of those, then you selected letter C, which is I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Do you think that still most accurately represents the way you feel of those choices?
Yes,
Okay. Do you believe that the death penalty, or would you be in favor of it in every case where a murder has been committed?
no,
All right. Just one final question for you then. Do you think there's anything at all about your views on the death penalty that could prevent or substantially impair your ability as a juror to perform your duty in this case and follow the court's instructions? All right, that concludes the questions the court has on the topic. Does the state have any questions?
We do not, Your Honor.
Any questions from the defense?
Just briefly, in your questionnaire, you said punishment, basically the punishment should be the crime, right? So if there were to be a conviction in a case, if it's a murder conviction, and one of the options is the death penalty or life in prison. In your position, if there was a conviction for a murder and there was enough evidence to support that there was a murder convicted, is your decision going to be for an automatic death penalty in that case?
no, it depends on the case. You could have a case where it's self-defense or anything, so no, it'll be based on the evidence.
Other than self-defense, if it's truly a conviction, they say, yes, this was determined to be a true conviction for murder and someone was murdered. Is that a case where it's an automatic death penalty?
No,
So if the judge were to instruct you that first you're to look at the evidence and make a determination. The second part would be to, after you make a determination, you're to evaluate all of the facts related to that case. And there are going to be 2 options. One will be life imprisonment. One will be the death penalty. Can you commit to us today that you will look at the facts and evidence when in the sentencing phase, if there were to be one, and make your decision based on the facts and the evidence of the case?
yes.
Thank you, and I appreciate that.
All right, that'll conclude the individual voir dire for this juror. So I'll go ahead and have you return with the bailiff to the jury room for further instructions. Let's next talk to juror 732. I'm sorry, 722. All right, thank you. Juror number 722, you're returning to discuss some of the information in your questionnaire outside the presence of the other jurors. The first thing that we want to discuss with you at this time would be your knowledge of this case and whether or not that may have led to you forming any kind of opinion. So I would note that The juror stated they followed the case somewhat and have some information about it. I'm also indicated they have not formed an opinion, but we need to discuss this further. So I'll let the state proceed with some individual voir dire to see if there's any bias here.
How are you today?
Good. In this case, you indicated that you watched some news on this case. And it didn't sound from your questionnaire like you had learned a lot about the case. But if you're comfortable, would you mind kind of telling me what you did learn about the case?
I actually did follow it quite a bit. I was interested, I guess, in it. So what I understood was just what the news said, and you don't know necessarily if that's or true or not. For whatever reason, it was interesting. I enjoyed learning about it, but I knew that I didn't have enough information for that case for me to make a judgment.
Did you watch any court proceedings in any other cases related to this case?
I remember there being an audio that was available for people, and I watched, listened to a bit of that, but not watched.
Okay. And what was that audio of?
I think it was a couple of days around the autopsies being shown in the pictures, just what the judge was saying and what the happenings of that episode. It's not an episode of that day.
Sure. Are you aware if that was a preliminary hearing or a trial or?
It was in the trial.
It was in the trial, and that would be the trial of
Lori
Gallo. Okay. Did you watch or listen to any other court proceedings surrounding the charges against Lori Gallo?
Not really, no.
Did you form any opinions about Lori Gallo and whether or not she was guilty?
No, it always just kind of confused me. I figured there was certainly stuff that went on that I didn't know about. And somehow it wasn't something I needed to worry about, but for whatever reason, it was something that was interesting.
And the evidence that you did listen to in the trial, did any of that relate to the defendant, Chad Daybell?
No.
And you understand that as Mr. Daybell sits here today, that he is innocent until the state meets its burden of proving him guilty.
Correct.
So he's entitled to a presumption of innocence.
Yes.
And you have not formed any opinions about Mr. Daybell's guilt?
No.
Your Honor, I have no further questions for this juror. Thank you.
All right, thank you, Ms. Fahey. Mr. Cryer.
Good morning.
Good morning.
Did you happen to watch any documentaries on this case?
I did watch one.
Which one was that?
I think it was the Netflix one.
Okay. Did you watch anything on Dateline?
No.
How much of the trial did you actually watch?
Probably like everybody here in the Boise area, you clicked on the headlines and read a bit of what occurred the day before.
Okay. But at least a portion of it, you took the time off out of your, and you have 6 children. You have a,
Well, I live alone now, so I'm an empty nester, so
okay.
not as busy anymore.
Okay, and I noticed that. So you did have the time to sit down and watch part of the trial if you felt you wanted to.
Yes.
And really what you were trying to do is just educate yourself about the facts of the case.
Correct.
Okay. And there was an interest there.
There was.
Okay. And as part of that interest, you have an idea about some of the facts and how you feel about those facts. Would that be fair?
Probably, yeah.
And part of the process is that despite your knowledge of the facts, despite whether you have an idea of what you think about the case at the present time, when you're making the decision, we would like you to be fair and impartial and be able to block out those images, block out that knowledge that you've gained. And you would agree with me that you've had extensive media exposure to this. Would that be fair?
Probably, yeah.
Quite a bit.
Yeah.
And there's been a very high interest in your regard about this case. Would that be fair?
Yes.
Other than your family, and people who are very important in your life, this was an important thing for you to look at, and you were drawn to this. Would that be fair?
Oh, I wouldn't say that it was really important, but you know, when you got home from work and you wanted to relax for a little bit, I checked the news and then I did a little bit more work, turned on the TV, you know, nothing terribly.
Right. Watched a documentary.
Yeah, I wasn't obsessive. That's
No.
what you were saying.
No. But you watched the documentary, you looked at some of the other stories, you sort of piqued your curiosity about that.
Right.
And it wasn't hard because, you know, you looked at a lot of things as part of this. Is that fair?
Right. Right.
So when the time comes, if you're chosen as a juror, you form sort of an impression in your mind about this case. Would that be fair?
Probably, but also at the same time, as my number was called and everything like that, I'm confident within myself that I wouldn't be impartial about it.
Okay. But, you know, and that's, I appreciate you saying that. I really do. Because it's important that despite the fact that you've had a massive amount of media exposure, you would agree with that, you have, right?
Mhm.
And the fact that you have, and I want to be careful, you formed an impression of this case.
Probably.
That you still think that you could go into the jury pool and be absolutely impartial and not consider what you learned about this case, maybe block this out despite the impression that you've already formed.
Yeah.
Okay.
I would be able to.
And Judge, I'll move for cause here.
All right, I've been listening through the questioning on this with juror 722. I had a couple of follow-up questions. You do seem to have somewhat actively followed that previous case. Did you watch, for example, the verdict in the case of Lori Vallow's trial?
I think I did. At the end of the day, it wasn't live.
All right, and do you know how her trial turned out?
I wouldn't be able to tell you the specifics of all the different charges, but, and they found her guilty.
Okay, and do you know what her sentence was? Or did you watch anything involving her sentencing?
I probably did a lot of it. I don't really think a lot about afterwards. But I think she got life.
All right, I appreciate your responses here. You've stated pretty unequivocally that you could be impartial in the case, and I'm not challenging or questioning that. The concern I just have here is whether or not implicitly that would sway your opinion one way or another, knowing what occurred in that other case, and most importantly, some knowledge and observation of evidence that was admitted, which may be the same evidence in this case, or may leave you wondering why evidence you saw in that case doesn't come into this case. I do find it problematic, and so for those reasons, I am going to sustain the request to strike this juror based on a bias in terms of too much information and knowledge about the other case that's already been through trial that would overlap this case. So for that reason, you'll be excused from your service. Thank you very much for taking the time to complete your questionnaire and coming back this morning, and you can be excused. You're welcome. All right, let's next talk to juror 732. All right, we are on the record with juror 732, who's returned here for individual questioning and voir dire. This juror has some case knowledge and may have some information about the case, so we're going to discuss that with you outside of the presence of other jurors. And I'd like to hear some inquiry from counsel as to whether or not there may be bias based on previous knowledge of facts of the case. So who's going to conduct voir dire for the state?
I will, Your Honor.
All right, Mr. Wood, you can commence.
Juror 732, just as a reminder, there's no wrong answers here. Just tell us how you feel, and there's no right or wrong. In your questionnaire, it sounds like you do know a little bit about this case, and you talked about info from early in the reporting. Do you recall what you saw and about when you saw it?
No, and most of my information, I think, is around missing children. That's something that would pique my interest. I am very selective in my news. I don't watch the news. I read the news. Trying to find balance between well informed and avoiding stuff that I think uncomfortable. So missing kids is priority, or an interest, or so I remember a little bit of information about that. Once it was on my radar that it was a potential murder trial or murder situation, I disconnected from the story.
Okay.
So really early on, I really avoided sensational stories. I like to see.
Understood.
If I can't impact something, I don't necessarily need to.
Okay. Do you recall, you said online news, what sources online news do you usually look at?
For local news, I use the three big Channel 7, Channel 2, Channel 6, their websites. I used to subscribe to the Statesman, so I would get some information from that Statesman. I no longer pay for those subscriptions, so I don't get that anymore. National news is usually BBC, Associated Press. As a general rule, I try to avoid things that are right.
Gotcha. On page 18 of your questionnaire, if you can turn to it, there's a question 8, and it's the what have you heard? And it seems like you know some of the basic facts and individuals involved.
I think that's largely headlines. You can't open it up and look through the news. When you see the headlines, you decide what you're going to read and what you're not going to read.
So you do say that in 8A, it says, could your knowledge of any of these individuals prevent you from acting impartially? You did say no. Is that still how you feel?
Correct.
And you, down on page 19, it says, where it asks if you'd be able to put what you have heard out of your mind and render an impartial verdict based solely upon the evidence presented in this courtroom. You do say yes. And is that still your position, that you can commit to this court, to this defendant, to the state, that you will not rely on anything you did learn in the media?
I can commit to that.
You did bring up one thing earlier, and I just want to talk about it real quick. And you talked about being able to sleep, and I think that's the second time maybe you've mentioned that today. Do you have any concerns about the subject matter of this case affecting you emotionally, mentally?
My guess is it would impact almost everybody in some way, shape, or form. That doesn't mean I don't take this responsibility seriously. I I don't mind live there, I don't watch true crime, I don't watch, I don't read thrillers, I don't read Stephen King. I'm pretty selective of what I take in. I worked in healthcare for 20 years. I spent a short period of time early in my nursing career in the emergency department. Part of the reason I didn't stay there long, that's not for me. I don't need to see gunshot wounds. I know there's a lot out there. I spent a lot of my career seeing some pretty horrific things. Natural causes, disease, accidents. So I have elected to not seek out additional. That doesn't mean I can't process it or deal with it, but I have been very selective, probably my whole entire life. What I choose to take in, and again, it goes back to what can I impact and what can I not impact. In healthcare, I think I could have an impact. That changes how you process things.
Well, and I guess a good way to ask this would be, so when you were in the ER and some type of traumatic injury came in, were you still able to work through that, work through your normal work obligations, provide the level of care you were supposed to provide?
Yes.
Okay. And would you be able to do that here, even if this subject matter were disturbing to you? And I think you said it correctly, it probably would impact anyone who looks at it. But even if you find it disturbing, that you will be able to set that disturbance aside and weigh the evidence just on the evidence and the facts, rather than any just disturbing aspect of it.
I'm sure.
Your Honor, the state has no further questions.
All right, thank you, Mr. Wood. Mr. Pryor.
And juror 732, I didn't hear whether did you see the Dateline and the Netflix series? Did you watch those? Did you watch any?
I didn't know there wasn't a
Perfect.
and I don't watch Dateline. I don't watch any news. I read news, but I don't watch.
So you get most of your information off the internet, but through the websites of these various news agencies. Is that fair?
Very fair.
Okay. And just something piqued my interest is that you said that you choose not to view that stuff as a way to sort of shelter yourself from those images and that stuff, because it is upsetting to you.
It is. And again, if I can't have an impact on something, I don't need to know about it.
Do you tend to react strongly to things like that?
I'll hold on to it.
What does that mean?
I still remember some really horrific patient scenarios from nursing school. I'm old, so that was a long time ago. But it doesn't mean I didn't do the right thing. It doesn't mean I didn't take care of my patient. It doesn't mean that I didn't need to be there. Somebody needs to be there.
In what you read, do you have some strong thoughts on what you read?
No, because I think I disconnected fairly early on. And not on any kind of level that would impact any kind of trial. But gosh, when my kids were in elementary school, they're in their 30s now, so that was a long time ago. There was a school board change in Ada County. And I was quoted in the newspaper, the Idaho Statesman. And it wasn't, I said everything that they printed. I said nothing in the context that it was printed. And I was really impacted by that. So that's shaped me in a lot of ways. I can read a lot of things, but before I'm going to pass judgment on anything, I want to know a lot more information. I think that's a little bit why I got hung up on your question. I didn't understand your question where you asked me how I felt about an 18-year-old wearing a 92-year-old? Or were you asking me about everything that glitters is gold? Because I have very different opinions.
Right.
I don't think there's anything illegal about an 18-year-old marrying a 92-year-old. If it's mutually beneficial, I'm not gonna pass judgment on that. That has nothing to do with me. So were you asking me about that, or were you asking me about everything that glitters isn't gold? I mean, there's different opinions. So I have limited my news probably for a lot of reasons. I don't need sensationalism. And I think you can have accuracy in reporting. I don't believe that there's malicious intent in reporting, probably in the vast majority of reporters, news agencies. I think they probably are presenting largely facts as they were told or that they know them at that time. Does that mean you know the whole story? Probably not. Does that mean things aren't going to come up later? Probably not. Could somebody be misquoted or out of context? I happen to know that personally. So
I appreciate that. So what it sounds like is that in spite of the fact that you may or may not have impressions, you may have impressions in this case, but it sounds like you can compartmentalize and you can say, listen, I can push that stuff away and make an unbiased and impartial decision, despite the fact that I may have had some exposure or I may have had some influence in some way, but I'm still going to be able to look at this independently in spite of the fact that I've been exposed to this.
I would agree with that. And I would fully expect that there'll be evidence today that wasn't reported on the news, even if I read all of the news. I mean, I'm sure there's facts that were never reported.
Okay.
So,
And in the same regard, you've obviously spoken about a sensitivity to graphic images and violence, and you make an effort to avoid that and say, I'm not going to let that into my sphere, for lack of a better word. Is that fair?
very fair.
Okay. And and please, this doesn't mean that your answers are right or wrong. I'm trying to figure out, and that's why we're talking so much in depth about this, because I don't know how to process some of the stuff you're saying. I guess my concern is that in this case, you're not going to be able to decide to keep these images out of your mind. And some of the images and discussion is going to be hurtful to the heart. And that's where I'm hesitating. Okay, I'm going to be honest, I am. Because I don't know if pushing it out and saying, yes, I'm going to be able to look at this independently, and I believe you have an ability to do that. You've worked in an emergency room, my goodness. So there must be some intestinal fortitude there. I mean, significant. But I am still concerned and always am concerned that maybe the impact that it could have on you could in some, even a small way, impact your decision. And that's where I hesitate a little bit.
That's valid. I don't think so. I think it goes back to, do I have the ability to have an impact? Do I have a need to know? I think if you're on if you're impaneled as a juror, if you're a part of a trial, you have an impact.
Right.
You have an impact on somebody's, in this case, somebody's life, not just livelihood. I also have there's an impact. But I think there is a need to know. I think,
Okay.
and that's different than just, in my mind, gratuitous sensationalism that I don't need to know. Would this be the highlight of my anything to be on this trial? Absolutely not. Do I think it's important? I couldn't believe more firmly in our judicial system.
Right.
So whether I want to be or not, it's an obligation. If I'm the right person, then that's what I'll do. If I'm not the right person, probably sleep easier.
So if I understand you correctly, and then please correct me, stop me and correct me. Despite all of the images and information that you've gained from this thing, At this point, despite the, you may have come to a conclusion or not, an impression. Despite that there's an impression because of the news and because of your sensitivity to graphics, you're going to tell me that you can block that out because there is I want to use the right word. You can make an impact on something. And because you can make an impact, you're going to make a concerted effort within yourself to say, I'm not going to let my previous knowledge, my previous decisions impact me. And even though I've made those decisions and I've come to some conclusions or understanding, I will block those conclusions and understanding out because I think I can make an impact by participating in this process. Is that fair?
That's fair.
Okay.
And I don't believe any prior information would have any impact.
Okay.
I think maybe you're questioning just the images. And I think
That's where we have to block.
that's where I have to.
Okay. All right. And again, there's no right or wrong answer, and I'm torn here. I'm going to be honest with you, I'm torn.
I'm not offended by that.
And Judge, I guess just because of the images, I think I'm just going to move for cause. I just think I have to.
All right. I've listened carefully to this exchange and considered the knowledge you have. The question I have, just to be succinct as I can, despite what you've seen and heard about this case, are you willing to commit to hold the government to its burden of proof in the case?
I think I could, yes.
Okay.
I mean, I don't foresee any reason why I couldn't fulfill my obligation.
All right. Based on the responses there, the state has not made a request to strike. The defense has. I'll overrule the request for perceived bias, although this juror has expressed some knowledge of the case. There's another topic we do need to discuss with you as well, and that is part of the questionnaire that you completed that had a section on attitudes regarding the death penalty. Do you remember reading through that section and answering your questions?
I do.
All right. And that starts on page 12. I will advise you that in this case, it may be necessary for you to actually make a determination in regard to the imposition of the death penalty or some other penalty. And remember that any penalty you're considering should be considered as if it is absolute and will be carried out in the case. So with that in context, do you support or oppose the death penalty? You selected a choice that said you support it. Is that still the way you feel right now?
Correct.
Okay, you next on page 13 had a series of choices, 7 of them about what accurately represents the way you feel. And you selected C, which states, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still an accurate representation of how you feel about the death penalty?
Yes.
All right. Where you are in favor of the death penalty, are you in favor of the death penalty in every case where a murder has been committed?
No.
All right, so I just have a final question there then. Will your views on the death penalty in any way prevent or substantially impair you from performing your duties in this case to follow all of the court's instructions, including those relating to the death penalty? All right, that concludes the court's voir dire on that topic. Does the state have any questions for juror 732?
Not on this topic, Your Honor, thank you.
No questions, Judge, thank you.
All right, that will conclude your individual voir dire. We'll have you return to the jury room with the bailiff, and you'll receive further instructions once we talk to the other jurors. Thank you. Next up will be juror 751. All right, thank you for returning. Juror number 751. We're going to conduct some individual questioning of you relating to your questionnaire responses. You indicated a little bit of knowledge. Well, I'll let you determine how much knowledge you have or don't. Didn't express a whole lot in the questionnaire, but raised your card that you know something about the case. And you also made a comment on page 18 of your questionnaire that only the report of them missing in their deaths when asked a question about the people listed in that question. You also did not indicate anything regarding trial hardship. So does the state have any inquiries that relates to bias on this juror?
Just a few quick questions, Your Honor.
Go ahead.
Morning, then. On that point that the court had made, you did make some comment that you had learned of the report of the deaths. How did you learn about that?
It was just media reporting. I don't follow the news, but it was on the broadcast. I don't know details. And I did not follow any of the other court proceedings prior to this. I don't normally watch the news.
So it is fair to say you haven't seen any documentaries, datelines?
No,
anything like that?
nothing of that nature.
You haven't read any articles online? So just with that report, is there anything about what little you apparently know about the case that you think would impact your ability to be impartial?
No.
All right, I have no questions.
No questions.
All right, thank you, counsel. Without further questions then or concern of hardship, the next topic we'll discuss with you relates to that part of the questionnaire where you were asked about your attitudes regarding the death penalty. Do you recall reading through that and answering those questions?
I do.
All right, since you filled out your questionnaire last week, have you had any change you'd like to indicate in terms of how you answered the questions there?
No.
All right, I do want to advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, as you consider that, consider it as if it would be done in absolute and carried out in the case. So knowing that, you answered in your questionnaire on the question, do you support or oppose the death penalty? You said support. Is that still the way you feel now?
It is if the evidence dictates that that's the appropriate punishment, yes.
Okay. You filled out another choice when given 7 choices about what most accurately represents the way you feel. And you said, and I'll quote from the questionnaire, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Is that the way you feel as well?
Yes, sir.
All right, and just to be clear, you said you support it, but you said also generally you're opposed to it, but would follow instructions about it if you needed to. Can you just explain maybe a little bit more how you feel about those 2 choices?
I'm assuming, given the instruction from the court, we will be given all the facts that lead up to this case. If the defendant is found guilty, then those instructions will follow as far as what it will be able to apply. It's what the law will allow. My personal opinion doesn't count. It's kind of like the black and white question.
Okay, so that part of your answer that said you would follow the instructions in the case, if you had personal feelings that were different, you still would be able to do that?
Yes.
All right. So based on those answers, then let me just ask you, would you be in favor of the death penalty in every case where a murder has been committed?
No.
Okay, and
Only
so,
facts.
apologies, go ahead.
Just if facts have proven the case, and that's what the choices are, with the individual case by case.
All right. Is there anything you think about your views on the death penalty that could prevent or substantially impair your ability to serve as a juror in this case and follow instructions about that?
No.
All right, that concludes the court's order for this juror on that topic. Does the state have any questions?
We have no questions, Your Honor.
Mr. Pryor.
I have no questions, Judge.
Okay, thank you so much for returning. That concludes your individual voir dire. We'll have you go back to the bailiff of the jury room and call another juror in. Seven, 9 is up next. Council, I didn't see any indication of case knowledge. Is there going to be any request to voir dire on bias from the state?
No, Your Honor, thank you.
None from the defense either.
Okay, thank you. All right, juror 779 is returning for additional voir dire. Having reviewed the questionnaire, I believe the only topic we would need to discuss are questions related to the death penalty. Does the state agree?
Yes, Your Honor.
Yes, Your Honor.
Okay, we won't have any further voir dire on bias or hardship for this juror then, but we will ask questions as it relates to those responses on the knowledge of, or I'm sorry, attitudes regarding the death penalty. So, juror number 779, do you recall filling out that part of your questionnaire that asked you about your attitudes on the death penalty?
Yes, I do, Your Honor.
All right, having thought about your answers since you filled it out last week, would you change anything in there and how you filled this out or correct anything there?
I don't think it would change it.
Okay. I'll advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. So as you're considering a penalty, you need to think about that as if it would be absolute and done and carried out in the case, okay? You had a couple of choices in one of our questions on page 12, and it was, do you support or oppose the death penalty? You did say you support the death penalty, is that correct?
Yeah.
And you still feel that way now?
Yes.
Okay, you also had a series of choices about what most accurately represents the way you feel. And you selected a choice on page 13 that says, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. So does that still explain the way you feel most accurately?
Yeah, I would say like it kind of depends on the situation, but I'm kind of in the middle when it comes to it. But when a certain situation comes up, then I'd say I'd support it.
Okay, and back to that answer, you're saying that if it were called for in this case by the facts, law, and instructions, you would be able to impose it?
Definitely.
Okay. Do you believe that you would be in favor of the death penalty in every case where a murder has been committed?
No.
Okay, I have one final question for you then. Is there anything about your views on the death penalty that you think could prevent or substantially impair your ability to serve as a juror in this case and follow any court instruction about the death penalty?
I believe so.
Okay, thank you for your responses. I'll ask if the state has any voir dire for this juror.
Your Honor, we do not. Thank you very much.
No questions, Your Honor.
All right, juror number 779, that concludes our questions for you individually. You'll return with the bailiff to the jury room and we'll have you back here shortly. Let's talk to juror 997. All right, thank you for returning to the courtroom, juror 997. We're going to ask you some individual questions now about responses in your questionnaire. There is some indication of some knowledge about the case in the questionnaire, and I'll ask if the state wishes to voir dire on that issue on bias.
Just briefly, Your Honor.
Go ahead, Mr. Wood.
Juror 997, in your questionnaire, you say you haven't followed the case, just heard some things on the local news a few years ago. Do you recall what you've heard?
I think I was walking through our front room. It was when our kids were younger. They were home and had the TV on. It was a local TV station stating something about the gentleman and the female that were involved. And I think maybe they showed photos of them, and that was it.
Okay. So you definitely have not spent a lot of time following the case.
Not at all. No.
On page 18, do you have your questionnaire with you?
Yes, sir.
Page 18, question 8. You do talk about that you're aware that there are children who have been killed in this case.
Correct.
And it says with the help of Chad. Now, is that with the help of Chad? Is that something that is that a belief you have, or just what you've heard?
Just what I heard.
I do notice in the next portion of that question, it says, could your knowledge of any individuals prevent you from acting impartially in this case? And you say no. So, and so it really, I guess, I just cut to the chase a bit. Is there anything that you've heard that would make it difficult for you to render an impartial verdict in this case?
No.
And you understand that this defendant has an absolute right to the presumption of innocence.
Absolutely.
Until the state proves otherwise. And so can you commit to putting anything you have learned out of your mind and only making any decisions in this case based on the evidence presented in the court in this case?
Absolutely.
I have no other questions at this time, Your Honor.
All right, thank you, Mr. Wood. Mr. Pryor.
No questions, Judge.
Okay. The next topic then the court will discuss will be relating to your attitudes regarding the death penalty. Juror number 997, in your questionnaire, there was a section about that, and you went through, read the questions and filled out your answers. Do you recall considering that section?
I believe so, yes.
Okay, and it's been some time since you filled out the questionnaire. Is there anything in your responses that you think you would change today?
No, sir.
All right, well, let me advise you that it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. And as you consider that, you need to think of it as if it would be done, absolute and carried out in the case. So with that context, then you had a choice of whether or not you oppose or support the death penalty, and you said you support the death penalty. Do you still agree with that in your opinion today?
Yes, sir.
Okay, you had a choice out of 7 of what most accurately represents the way you feel, and you selected a choice that reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the way you feel?
Yes, sir.
And to be clear then, you would follow any instructions in the case provided by the court on the death penalty?
Yes, sir.
Are you in favor of the death penalty in every case where a murder has been committed?
No, sir, I'm not.
Okay, is there anything about your views on the death penalty that you think could prevent or substantially impair your ability to serve as a juror in this case and follow the court's instructions about the death penalty?
No, sir.
Okay, thanks for your responses. I'll ask if the state has any voir dire.
Not on this subject, Your Honor, thank you.
No question, Judge. Thank
All right, counsel, that will conclude the individual voir dire of juror 997. You'll return to the jury room with the bailiff and we'll talk to you again shortly. Next up will be juror 1078. All right, juror 1078. Welcome back. We have some individual questions for you. In review of the questionnaire, I didn't see any indication of case knowledge or potential bias. Is the state intending to voir dire on that topic at all?
Judge, we do have just one bias question.
All right, why don't you commence with that then, Mr. Wixon?
Thank you. Ma'am, do you have your questionnaire with you?
Yes.
I just invite you to go to page 7. Excuse me. And on page 7, under part 4, 1A, it says, do you feel that a defendant should be required to testify? Did you mark that? Yes.
Yes.
Could you explain what you mean by that?
I think when I filled this out, I didn't really understand what that meant exactly, but after what we heard today, what I learned today, I understand that he has to need to, and it's not required. Yeah, I just wasn't clear.
Fair enough, fair enough. So is it fair to say that if you're on the jury and the defendant chose not to testify and to remain silent, you wouldn't hold that against him in any way?
No, now that I understand, it's not required.
Thank you. Your Honor, I don't have any more questions.
No question, Judge. Thank you.
All right, thanks, counsel. There's one more topic then we'll discuss with you. In your questionnaire, starting on page 12, we had you read through and answer some questions on your attitudes regarding the death penalty. Do you recall going through those questions and answering them?
Mm-hmm. Yeah.
Okay. Having thought about your answers since you filled this out last week, is there anything you think you would change on any opinion you've given here?
No, I don't think so.
Okay. I do want to advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. So thinking about that, you had a choice on page 12, whether or not you support or oppose the death penalty, and you said you support it. Is that still the way you feel now?
Yes.
Okay, if you could look on the next page on 13, you were provided 7 different choices of what most accurately represents the way you feel, and you chose D, which reads, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Does that still accurately represent the way you feel about the death penalty?
Yes.
And would you be able to follow any instructions the court gave in this case if you had to consider that?
Yeah.
All right, I'll next ask you, are you in favor of the death penalty in every case where a murder has been committed?
No.
Okay. Finally then, is there anything about your views on the death penalty that would prevent or substantially impair your ability to serve as a juror in this case and follow the court's instructions?
No.
Okay, thank you for your responses. I'll see if there's any voir dire from the state.
We have no questions, Your Honor.
No questions. Thank you.
Okay, thank you for returning that conclusion, individual voir dire. Final juror will be 1100. All right, welcome back, juror number 1100. We have some additional questions for you individually here. I would note that you did raise your card when we asked if you knew something about the case. You mentioned a little bit about that in your questionnaire also, saying also you did not follow the case. And then I'll just ask the state if the state would like to commence with individual voir dire for this juror on the issue of bias.
Yes, Your Honor, thank you.
Go ahead.
Good morning, sir.
Morning.
So you indicated on your questionnaire that you'd had a little bit of media exposure to this
Yeah.
case?
I mean, I listen to the radio, I watch TV reports and things like that, so it'd be hard to miss
Of course.
something. So yes, I'm aware that the case existed, but as far as I was concerned, it was over with. I mean, it's been what, 3 years or something like that. I just know it's been long.
Thank you. So this might sound like kind of an odd question, but what do you know about the case? Just kind of an overview.
All I know is that there were some deaths that occurred. I do know that that's the one thing that stuck in my mind. I don't even know why. Is that people had gone to Hawaii. That's the only thing I can remember.
And do you know what people had gone to Hawaii
I don't.
that you saw in the news? Okay.
Okay.
And would you be able to set aside whatever you've heard on the news and only consider the evidence that's introduced in trial in this case?
I will do that.
And sir, you'll be instructed that Mr. Daybell is entitled to a presumption of innocence until the state meets its burden of proof beyond a reasonable doubt. Are you okay with that?
I am. I think I need to probably have a little bit better understanding of where that line is of reasonable doubt. That's one
Of
thing
course.
I tried to understand. And so from my standpoint, I don't know where that line is drawn.
And you'll be instructed on that by the judge. The judge will provide you several instructions, and one of those instructions will be a definition of reasonable doubt that you will have. But for today's purposes, I just want to make sure that you can start this trial with a clean slate, giving Mr. Daybell the presumption of innocence that he's entitled to.
I believe that I can do that.
Okay, thank you very much, sir. I have no additional questions, Your Honor.
All right, voir dire from the defense.
And again, sir, there's no right or wrong answer. There's no right or wrong answer here. We're just trying to get your feelings and your impressions, and this is a chance for us to talk a little bit, to delve in deeper about things. So please don't take any offense to what I ask. Thank you. Do you have your questionnaire with you?
I do.
And I would turn to page 19. Item.
I have it in front of me.
Okay, item number 10, and I want you to go to 10D. And let me know when you're there.
I'm at 10D on
Okay.
19.
And I'm going to read this so that we, and then stop me if you need to. And it reads as follows. Has any of your possible exposure to the news media, dramatized depictions, or other publicity around the case caused you to, and you underlined, form an opinion about Chad Daybell's guilt or innocence. And your response, you didn't mark the yes or no, but you said possibly because of their nature, but understand that I would need to evaluate the info at trial. So if I understand what you said there, and don't let me put words in your mouth, okay? Please clarify that and say what you need to say.
Okay.
I've gone through a number of these, and then there are a lot of people that say that. They say, you know what, at the time of trial, I can evaluate and look at the evidence independently, despite the fact that I may have some information that leads me one way or the other. Okay? And I have no doubt, and I think, I guess if you would commit to this, at the time of trial, you would be able to look at the evidence and make a determination based on what you hear during the trial, right?
I believe that I can, yes.
Okay, and that's where I'm struggling a little bit.
Okay.
Because part of your answer said possibly, and what I read that to mean is that you already have some impressions in your mind. You already have some images, and you have an idea of what you think about this case, right?
Yes, because of the nature of those reports.
Right.
You talked about that earlier.
Right.
And that, you know, sometimes when media is doing things, they do that with, you know, an intent to convince, sometimes with an agenda.
Right.
And so there's no doubt that because of the things that I heard and saw, you don't form some sort of an opinion. People always come up with some sort of advice. I don't think anybody would be, they would be dishonest if they weren't telling you that there wasn't some sort of a bias that does come into that. But I believe that now being asked, if I were to be asked to be a juror, then I have to set all that aside and I have to then look at the information that is presented.
And you know what? I respect and admire your honesty. I really do, because you know that says a lot. That what you're willing to do is you're willing to evaluate this case at the time, despite the fact that you've had access, and despite the fact that you've seen some things and listened to some things, and that you've formed an opinion based on what you've said from these folks in the media who sensationalize things, right? But that has caused you to form an opinion at this point. But despite that, you're willing to sit down and look at this thing and make a determination. Would that be fair?
I am, yes.
Okay. And please don't take offense to anything I say. And again, there's no right or wrong answer. It's just we have to look at this in a certain way, and that's why we have the jobs that we do, okay? And Judge, I'm gonna move for pause on this one.
All right, response from the state?
Your Honor, if I could ask just one question.
Yes.
Sir, I don't know if I missed it, but I believe Mr. Pryor had made some reference to you forming an opinion. Have you formed an opinion? And if so, what is that opinion?
Well, the opinion is just that it was an egregious crime that occurred, and that the people that have been identified were more than likely those folks who, again, were involved in whatever occurred. And again, I don't know the details now, other than just the little things that I heard on the news.
Okay. And do you know who those people were?
I didn't even know the names until I got called on this, and it's been mentioned who the case was about. That's all.
Okay. Would you be able to set aside what you've heard on the news and just consider the evidence in this case?
Yes, I will.
Okay. Your Honor, I'd submit to the court.
All right, and not to prolong things unnecessarily, but there were a few other comments that came up that I think in fairness, Mr. Pryor, if you have any additional voir dire on his statement, you can proceed. If not, I'll make a determination.
So on number D, you talked about that you have formed an opinion, but you're willing to set that aside. Is that correct?
Yes, it's not a strong opinion. It's just, I knew that at one point in time I had formed an opinion.
And then underneath that, there's item number F. Have you formed a personal opinion whatsoever based on information from any source of Chad Daybell's guilt or innocence or anything? And you said not beyond D above. And what that's saying is whether Chad's guilty, he's one of the parties, obviously, to the media that you saw. Is that right?
Yes, I mean, and now know in this context that
Right, he's one of the
that
parties.
he's one of the parties.
And you formed an opinion that, and you're willing to evaluate the information that's presented to you if you're picked as a juror, but that's going to require you to say, listen, I'm willing to set aside my personal opinion about Mr. Daybell's guilt and evaluate this independently. Is that what you're saying?
I am, I believe that I've already done that by
Okay.
the fact that I've now been asked to be a juror.
Okay.
So then you have to go back to ground zero in my mind
Okay.
and start over. But again, to be honest, I have to say that it's natural for someone to hear those reports and to
Right.
immediately assume at the beginning that that stuff is correct.
And that's something that we all have to discipline ourselves with, right?
Correct.
When you're in a situation, all of us, and I agree, when you read something and you look at information and you're exposed to the variety of the information, you form an opinion.
Yes.
And what has to happen is you have to make a discipline yourself to say, in spite of the fact that I've formed an opinion, and in spite of the fact that I've sort of decided this is what I sort of think, I'm going to set my opinion aside and work towards trying to be fair based on the information I hear at trial, right?
That's correct. I've had to do that many times in my life.
Okay, and did you hear anything else about any other co-defendants in this case of any kind?
No, I just know that there was the deaths that occurred, and I also know that there were people who were identified. And I can't tell you even how many at this point until it was gone over the charges.
Right. And so you'll agree to set aside your opinion that you've put together today. And based on that, you'll try to discipline yourself. You said you'll try.
Yes, I will.
Okay. Judge, if I could just have a moment.
Yes.
Nothing else, Judge.
All right. I have a couple of follow-up questions, Juror 1100. So just knowing what you do know, would you think this defendant here, Mr. Daybell, would need to somehow convince you or show you some proof that he's not guilty?
No.
All right. Given what you do know about the case or what you've seen or heard, will you commit that you would follow the court's instructions and hold the government to its burden of proof?
I will.
All right, the court is on this juror going to find that there's not a bias or prejudice at this stage that would prevent his service based on previous knowledge of the case, so the challenge is overruled. We have one other area to go through with you then, juror number 1100. You did fill out a questionnaire asking you about your attitudes on the death penalty. Do you remember that?
I do.
Okay, I want to advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, as you consider that, you must consider it as if it would be done in absolute and carried out in the case. Do you understand that?
I do.
All right, when you filled out your questionnaire, you were given a choice of whether you support or oppose the death penalty, and you clicked a box of support and said, as the law instructs. Is that still the way you feel today?
What page is that on?
This will be on page 12.
Can't have that.
Is that still the way you feel today in terms of your attitudes on the death penalty?
It is still the case that I do support that, but again, it needs needs to be in the appropriate context.
Okay. If you look at page 13, you had several choices here. What most accurately represents the way you feel? And you ultimately circled C, which reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. It looks like also you were really thinking about D because you kind of bracketed that a little bit and also underlined part of it. So is between those two, if you had to pick one, is C still your choice?
It has to be C, that's correct.
Okay. And are you willing to follow the facts, law, and instructions provided in this case if you're considering the death penalty?
I will do that.
Do you believe that you would be in favor of the death penalty in every case where a murder has been committed?
No.
All right. Finally, is there anything about your personal views on the death penalty that you think would substantially impair or prevent you from serving as a juror in this case and following any instructions about the death penalty?
I don't think there is.
All right. Thank you for thinking through those questions and answering them for the court. Does the state have any follow-up for Dyer on that topic?
I don't. Thank you, Your Honor.
Any follow-up from the defense?
Ever so briefly, sir, when we go back to page 13, you had your number that you marked as number C, if I remember right. Is that correct?
I had marked C and D was just kind of bracketed into it.
Right. And what I guess I'm asking you is that there's if there were a neutral, a box that said neutral between C and D, and that was one of the options, and the neutral said, I'm neutral on this issue, but I'm only going to base my decision on the facts and evidence. Would that more likely reflect your perspective on this?
That's correct. I saw these as rated in a scale, if you will.
Right.
Descending, whatever.
Right, but again, if there was a neutral, you would say, you know, I'm more neutral on this, and I'm going to listen to the facts and evidence before I make a decision.
That's correct.
All right, Judge, I have nothing else. Thank you, Your Honor. I appreciate the time.
All right, juror number 1100 then. We will pass that juror for cause on the others, and I don't know if it's more efficient to have him remain and have the others brought back or have him return and brought back with everybody. Let's have juror 1100 go back in the jury room, and then we'll have the remaining jurors brought back in once they're ready.
All right, please. Haven't gone here, Your Honor.
All right, thank you. Please be seated. All right, for those jurors that have returned, if you do us a favor one last time, and please just hold your red cards up so we can all confirm with our charts who's remaining. Okay, thank you. Having considered now these remaining jurors and concluded individual and group voir dire, does the state pass this small group for cause?
Yes, Your Honor, thank you.
Does the defense pass this group for cause?
Yes, Judge, thank you.
All right, ladies and gentlemen of the jury, then you have now been passed for cause. We will continue to question additional small groups until we reach the necessary number of jurors for the attorneys to exercise their peremptory challenges. You'll be leaving today and instructed to contact the jury commissioner, Randy Rutland. He will provide you further instructions on when you will return again. And you are going to be returning one more time for the peremptory challenges stage of this trial. We're not entirely sure of when that will happen. So between now and when it does, please continue to follow the court's instruction to not investigate the case, look the case up, talk to anyone about the facts of the case, or do anything else that may cause you to become impartial or exposed to facts about the case you shouldn't know before trial. Also, you can talk to people, family, friends, employers, etc., about the possibility of your service and when that may occur, but just please refrain from engaging in any discussion with them at all about the case. You will be asked to complete another affirmation as you did today when you come back, indicating that you have followed that court's instruction. So thank you again for your time. You'll receive those further instructions, and at this time, I believe we'll have you excused. Is the state okay to have this group excused for the day?
Yes, Your Honor, thank you.
That's all right with that as well?
Yes, Your Honor.
Okay, thanks. All right, for the jury. All right. Thank you. Please be seated. All right, we're scheduled to have another group returning at 1:30 this afternoon. Is council ready and prepared to do that after lunch?
Yes, Your Honor.
Mr. Pryor?
Yes, Your Honor.
Okay, thanks all. We'll be in recess then until 1:30 when we'll reconvene with another group of jurors.
Thank you. All rise.
Be seated. All right, good afternoon, Ward. Okay, we're back on the record on case CR 22-21-1623, State of Idaho versus Chad Daybell. We're going through small group for Dyer. This afternoon, we have another group here, and we'll have the jurors brought in. We are going to speak to one juror outside of the presence of the courtroom, and then we will return back with those remaining jurors for Dyer. At this time, I'll instruct the marshals to please have those jurors brought in with the exception of the one.
All right, please.
Hands are here, Your Honor. Thank you. Please be seated. All right, ladies and gentlemen of the jury, we're going to get started here momentarily with the group for Dyer. However, first the court's going to meet with counsel briefly to discuss one particular juror, so we'll do that, please, in the jury room. I'll just meet with the state and the defense, please. Thank you. Please be seated. Okay, we are back on the record now on case CR 22211623, State of Idaho versus Chad Daybell. Doing voir dire of a small group this afternoon. Is the state ready to proceed?
Yes, Your Honor, thank you.
Is the defense ready to proceed?
Yes, Your Honor.
All right, thank you. I'll note on the record, I just met with one juror as well as counsel for both the state and the defense in chambers, juror 1187, who upon further review of the questionnaire and motion of the state as well as the defense has been excused for bias expressed in the questionnaire, in addition for a hardship as well. So we've allowed that juror to be excused, and we will next move on to the other jurors here. I will also indicate, last I heard, we had a juror scheduled for this group. Empty seat on the back row, juror 1605. Apparently has failed to appear and we haven't had word from them. Is that the latest status on this juror? All right, thank you, Mr. Bailiff. So juror 1605 has not appeared. With that then, in order to make sure we're all lining up our seating charts with where you are and who's here, if you do me a favor, please, and just hold your red card up and leave it up here for a moment while we take our notes. Okay, thank you for doing that. Having confirmed where these jurors are seated and who's here, then let me first inquire from the state, is there any objection to the manner in which this jury panel has been recalled and seated?
No, Your Honor, thank you.
Any objection from the defense?
No, Your Honor.
All right, thank you, counsel. Ladies and gentlemen of the jury, thank you for returning this afternoon. You've been recalled as prospective jurors in the case now before us. I'll reintroduce my court staff again and myself. I'm Stephen W. Boyce. I'm the district judge for Fremont County, Idaho, and I'm in charge of this trial in this courtroom. Our court clerk assisting today is Shannon Holstein, who's seated to my right. She takes minutes of these proceedings and also administers oaths to you as jurors. The court, I have assisting me in maintaining courtroom order and working with the jury, our marshals here today, and they will help the jurors know where they're supposed to be as they move about for these proceedings. Also, our court reporter, Mary Fox, takes a stenographic record of everything said during the trial, including today, and Courtney Stallings is my staff attorney who assists me with legal and administrative issues that come out throughout the day. Each one of you is qualified to serve as a juror of this court, and each one of you filled out a questionnaire that's now been reviewed by the attorneys and the court. And the first thing we do in a trial is to select 18 jurors in this case, which would include 12 jurors for trial and 6 alternates from among you. At this time, then, I am going to have clerk please take a roll call of the jurors that are here present. So when your name's mentioned, please hold up your red card and state either present or here so we get a record of who is attending. Madam Clerk, if you please take the roll call at this time.
Juror 977. Here. Juror 1185.
Here.
Juror 1219.
Here.
Juror 1248. Here. Juror 1271.
Here.
Juror 1288.
Here.
Juror 1330. Here. Juror 1353.
Here.
Juror 1366. Here. Juror 1382. Here. Juror 1436. Here. Juror 1503.
Here.
Juror 1537.
Here.
Juror 1557. Here. And Juror 1632.
All right, thank you, Madam Clerk. At this time, as I mentioned, we do have one juror who failed to appear, and for that juror, the court will require they report either by 5 p.m. or provide some explanation for the failure to appear. If there is no good explanation or further appearance, they may be subject to a fine up to $500 or imprisonment up to 5 days in county jail. That's pursuant to Idaho Code 7610 and Idaho Code 2208. Next, I am going to introduce you and to assist in participating in the jury selection process to the parties and their lawyers, and I'll briefly summarize what this case is about. When I introduce an individual, please stand and briefly face the jury panel, then retake your seat. This case has been brought by the state of Idaho. I will sometimes refer to the state as the prosecution. State's represented in this trial by Lindsay Blake, Fremont County Prosecutor, Rob Wood, Madison County Prosecutor, Ingrid Beatty is a specially appointed prosecutor in the case, and Rocky Wixom, a deputy Fremont County Prosecutor. The defendant in this case, Chad Daybell, is represented by his lawyer, John Pryor.
Good afternoon.
This case is a criminal matter, meaning the defendant is charged by the state of Idaho with a violation of the law. I previously read you a summary of the charges in the amended indictment, and you were here last week to complete your questionnaires. With regard to the defendant, the state of Idaho alleges that Chad Daybell committed the following crimes. Count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. Count 6, first-degree murder. Count 7, insurance fraud. Count 9, insurance fraud. Mr. Daybell has pled not guilty to the charges. Please remember that is simply a description of the charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence, you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instruction as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be, or what any lawyer may state the law to be. During the course of this trial, including this jury selection process, you are instructed that you are not to discuss the case among yourselves or with anyone else, including any use of email, text messaging, social media, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, I'm going to request that the clerk administer an oath to the entire jury panel for voir dire examination. If each of you would please stand and raise your right hand, I'll have that oath administered now.
You solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial, so help you God.
I do.
All right, thank you. Please be seated. Clerk has now impaneled this group of prospective jurors for questioning. Will the attorney stipulate that the jurors have been properly called and impaneled, beginning with the state?
Yes, Your Honor, thank you.
Yes, Your Honor.
All right, thank you. The attorney's then so stipulated. In this part of the jury selection, you're going to be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of common law, and in Old French it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand this questioning is not for the purpose of prying into your personal affairs. It's only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your hand or your red card. And when called upon to speak, please identify yourself by your card number. And also, these proceedings are being stenographically recorded. So give a verbal response such as yes or no. Shaking your head or nodding doesn't pick up and make a record. And also on that point, please try to avoid speaking at the same time as anyone questioning you. When only one person's talking at a time, our court reporter is able to make a clear record. I'll also note that the proceedings here are not only open to the public, but being broadcast on a court's channel on YouTube for public access. You are not being videoed or filmed. However, your audible responses are being broadcast. Keep that in mind when answering these questions. And if any question you believe would be embarrassing or something uncomfortable for you to talk about publicly, we will arrange to let you discuss that in a more private setting. Also, if you have an answer to some question that you think may prejudice the other jurors or some information they may not know about the case, for example, please don't discuss that in front of the other jurors, and we'll talk to you individually about that. This case has had a lot of pretrial media coverage, and so any facts you may know, we'll talk to you one by one, and please don't discuss those in front of the rest of the jury panel. At this time, I am going to read you a special instruction being provided in this case, and this is as follows. The defendant, Chad Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Vallow Daybell and or Alex Cox. The crime of conspiracy involves an agreement by two or more persons to commit a crime. You must only consider the evidence against the defendant in this case and should not speculate as to any other case or legal proceedings involving the alleged co-conspirators. You must remember that the defendant has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. That concludes the special instruction. At this time, I would also instruct attorneys for both parties to avoid repeating questions the court's already asked. You do have the right, however, to direct follow-up questions to a juror regarding that juror's response to a previous question. The jury should be aware that during and following the voir dire examination, one or more of you may be challenged. Each side has challenges called for cause, which means that they can ask a juror to be excused for a specific reason. In addition, each side has a certain number of peremptory challenges, which means each side can ask that a juror be excused without giving any reason. If you are excused by either side, please do not feel offended or feel that your honesty and integrity has been questioned. It has not. In addition, you may be questioned about your jury service once you're excused. If you are questioned by anyone, including members of the media, you are permitted to talk to them, but I would encourage you to respect the feelings of your fellow jurors, to not discuss anything that you think may impede the court in selecting an impartial jury while we're in this process. And if you don't want to talk to them and they persist, you could report that to the court. At this time, the court is going to begin its portion of the voir dire process, after which the attorneys for both parties will be given an opportunity to make their own inquiries. When I'm asking questions to certain jurors, please pay attention to those, as you may be called upon later to answer the same questions. First question I'll ask relates not the 22-page questionnaire you filled, but a juror information form, which contains information such as your residency in Ada County, for example. Is there anyone here that thinks the information in your juror information form is inaccurate and would need to be corrected? Okay, no one answered to that. I'll next ask on the questionnaire then, and without necessarily getting into the details, because those will be discussed, but is there anything you think within your questionnaire that at this stage you just need to change or correct? All right, no one responded to that. The next matter I want to bring up relates to the time commitment for this trial. This is scheduled to be a long trial, and parties have estimated it will take approximately 8 to 10 weeks. Given that time frame, would such service create a hardship upon you or your family or your business or profession or occupation so as to prevent you from rendering service as a fair and impartial juror in this case? If you believe you do have a hardship given the length of the trial, please raise your red card. All right, we've got 2 jurors that have responded to that. On the front row, could you raise yours again, please? Thank you. All right, at this point then, I'm going to address those hardship requests individually. So we'll start with the first juror on the front row, number 1248.
Should I go?
I was just reviewing your questionnaire real quick to see what you indicated. You did check the yes box for whether you thought there was a hardship. You said working full-time and losing that much income would be a financial burden. Have you been able to discuss your possible service with your employer in this case?
I discussed that with HR yesterday. They would only be able to cover 2 weeks.
And that is what they just confirmed yesterday?
Yes.
All right. Is that your sole source of income?
It is.
And if you were to be out 8 weeks of pay, would that financially strain you?
It would.
All right. Any follow-up questions from the state on a voir dire for hardship for this juror?
No, Your Honor, we actually had a note to follow up with juror 1248. I think given that additional information today, the state would make a motion to move for cause for the hardship. And that's exactly what we were going to follow up with today.
All right. Any voir dire from the defense?
Judge, we would also need to excuse.
Very well. Juror 1248, we appreciate you coming in and taking the time to fill out the questionnaire and returning. I understand with that being your sole source of income and the length of this trial, that would constitute a hardship for you, so you can be excused from service. The bailiff will take your questionnaire, and thanks again for coming in. Juror number 1632 has indicated they would have a hardship also. You did mention in your questionnaire a concern about a trip planned, I think early June. Could you give some more explanation about what the trip is, when it is, and if it could be changed?
Trip is planned for June 4th through June 12th. So vacation, family reunion. Supposed to be canceled. I also do, as far as family, take my kid to school. My wife is a teacher who is starting her workday before our kids' school day.
Follow-up voir dire, please, from the state.
Your Honor, the state does not have any additional questions. We would simply submit to the court on this one.
I'll have a bit of a follow-up on the plans you have on that trip. Have you pre-purchased or already paid for anything such as flights?
They have not been purchased by me, they are being purchased by a family member. Essentially, it could be put off.
Okay. Mr. Pryor.
Tell me a little bit more about the family. It's a large extended family or?
I don't have a large family. I do have family in Alabama that
That's
is,
what the family reunion, that's where it's going.
yeah, my dad's side of the family.
So how many people are we talking about?
It's my family, my parents, my brother and his wife, and then the people that live down there. Half dozen to a dozen.
Okay, and this was, what I recall is that this was reset as a result of COVID for some reason, right?
Correct. Yeah, back in, I don't remember the specific date, but back in 2020 or 2021, it was canceled because of COVID, yes.
And are other relatives flying in from other parts of the country as well?
Just my brother and his wife are flying in from Maine.
Judge, I'm gonna submit to the court.
Juror 1632, if you remained in and missed the trip, do you think that would become a distraction for you, knowing that you missed out on a trip that's been planned for several years here?
Possibly.
I understand. Given that it was already rescheduled and canceled once, it is a long trial. There's a likelihood we may well be in the trial on those dates. I am going to permit, for your request, the excusal for hardship. In addition, with your child care obligations as well, court will find you can be excused. So juror number 1632, thank you for coming in and completing your questionnaire.
Thank you.
You're welcome. Did anyone else have a concern on that issue they wanted to raise with the court? All right, well, thanks everyone for your commitment to being available for that time frame. The next issue we'll bring up then relates to whether or not you have any previous knowledge of this case. This case has had significant exposure and reporting in the media. If you have had any knowledge of that case, we'll discuss that with you individually. So all I'll ask at this time is if you do have some knowledge of this case, the facts of this case, or the issues involved within this case, would you please raise your red card? Or your hand, okay. If you'll give us a moment, we'll note these down. All right, thank you. We'll come back and question you individually about those matters. Next topic I'll raise is the subject matter of the case. I've read to you the charges. Would the subject matter of this case, including charges involving murder, conspiracy, and insurance fraud, make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict? No one answered yes to that. I'll next ask a series of questions that will seem very obvious perhaps to you, but I'm required to ask them under Idaho law to ensure that you don't have any kind of improper connection to this case or any of the people involved in the case. So the first question along those lines is, are you related by blood or marriage to the defendant, Mr. Daybell, or do you know him from any kind of business or social relationship? No one said yes. Do any of you have a legal relationship such as guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger? Any of those kinds of relationships between any of you and any of the attorneys in the case? No one said yes to that. Are any of you a party in any civil action lawsuit against Mr. Daybell? No answer to that. Have any of you ever brought a criminal complaint against Mr. Daybell or been accused of a crime by any of the prosecutors that are here present today? No one responded to that. Do any of you have any kind of an attorney-client relationship with Mr. Pryor, either now or in the past, or his law firm? No one responded to that. Are any of you related by blood or marriage to any of the lawyers here, or do any of you know any of the lawyers from a professional, business, or social relationship? No response. Have any of you ever formed or expressed an unqualified opinion that the defendant is guilty or not guilty of the offense charged? There's no response there. Do any of you have any bias or prejudice either for or against the defendant, Mr. Daybell? There's no response there. Are any of you unwilling to follow the court's instructions as to the law you must apply in determining this case? No response. Do any of you have a religious or moral position that would make it impossible to sit in judgment of another or to render a fair and impartial verdict? No response to that. Are there any of you that if you are selected as a juror in this case, would you be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as instructed by the court? There's no response to that. I have one final question then. Do any of you have any other reason why you cannot give this case your undivided attention and render a fair and impartial verdict? All right, no one responded to that. That will conclude the report section of voir dire examination. I'll next allow the state to proceed with its voir dire group. Is that going to be Ms. Blake?
It is, Your Honor.
All right, Ms. Blake, you can proceed.
Thank you. And ladies and gentlemen, thank you for being back this afternoon. I know this has already been quite a process. You were all here last week to fill out a questionnaire. Now we have you back here today. We are going to go over questions with you today, just to get some information. I want to go over a little bit why we're doing that. As you sit here today as potential jurors, what we're trying to do is make sure we select a jury that feels that they can be fair and impartial and that they can hear all the evidence in this case, give it the weight they think it's due, and ultimately render a decision and a verdict in this matter. So we go through this, the defendant, Chad Daybell, is entitled to a fair trial, and the state of Idaho is also entitled to a fair trial. So that's why we go through these questions. We just want to ensure that that's what both parties receive. So as I ask you questions, I don't want anyone to feel like I'm picking on you, but I will call on some people, get some responses, and just kind of go from there. Also, as we do this, the judge has already told you, but if at any time I ask you something that you're not comfortable talking about in a group setting, that is totally fine. I may ask something that I have no idea, maybe something personal, something that you'd rather talk about not in front of everyone. Just let us know, and we'll do our best to make those accommodations. This is not meant to make anyone feel uncomfortable. That being said, I want to start with throwing out the term brutal honesty. I want you to think about that for a minute. And juror 1219, if you hear the term brutal honesty, what does that mean to you?
Seeing the facts for what they are and speaking your mind.
Thank you for that. And juror 1537, how about for you?
Just telling the truth, I guess.
Thank you. I appreciate both those responses. And would everyone agree that it may also mean you don't hold back, even if it might hurt someone's feelings. You're not going to do a white lie. You're not going to spare feelings. It's just going to be telling it how it is. Would everyone agree that that would be being truly honest or brutally honest with someone?
Yes.
Thank you. And the reason I go over that with all of you is as you sit here today, there's two reasons for this. One is today as we're going through this, I'm going to ask you all to be brutally honest. Don't hold back. If there's something you think we need to know, either party, tell us. That's what we're here for today. And the second part of it is, as we go through everything, if you're selected to be a juror, at some point, the judge will give you jury instructions. And he'll tell you at what point you can start deliberating with each other. And we need to make sure that when you're back deliberating, you can also be brutally honest or honest with each other as you go through that process. Hearing that today, does that cause any concerns for anyone? No.
No.
Thank you. And we all may have someone that we know is kind of our go-to. So for me, my oldest niece, I learned pretty quick when she was little. She hadn't learned any filter. She hadn't learned kind of the little white lies or to spare feelings. So if I truly wanted to know something, I could go to her. If I wanted to know how my hair looked or how an outfit looked, she just gave it to me straight. And do most of you have someone like that in your life, whether a kid or a trusted adult that you know you can go to for just the straight answer?
Yeah.
That's what we're asking you to do today. Just be that person for all of us here. Have all of you flown on a plane before?
Yes.
Like everyone has. So normally you get on the plane and at some point they tell you, hey, sit back, enjoy your flight. We're going to get to the destination at approximately such and such time. And they take off. If instead of hearing that announcement, you got on the plane and the pilot came over the PA and said, so I'm going to try to land the plane and I think we're going to get to the destination at this time and I'll do my best. Would any of you feel comfortable staying on that plane?
No.
And juror 1577, I think I saw a pretty emphatic shake of your head. Why wouldn't you feel comfortable staying on that plane?
Because there's too much doubt. There's doubt that I would make it.
You want that assurance. That's fair. And juror 1353, how about you?
I would hope he was joking.
And I think that's a fair answer as well. And the reason I bring that up is you're all going to be the pilot in this case, essentially. And we want to make sure that everyone can give us the assurance that, again, we've kind of talked about it, but that you'll be able to sit on the jury, hear the evidence, give it the weight you think it's due, and land the plane. Be able to give us that verdict after listening to everything and to be fair and impartial in doing it. Does anyone sitting here today have any concerns about your ability to do that? Thank you. The judge already talked to you a little bit about the charges in this case. And so as you all know, there's several counts of conspiracy to commit first-degree murder. And there are also several counts of first-degree murder. The victims in this case involve 2 children and a mother of 5. Because of the nature of the case, you will see some images that may be graphic. They may be disturbing to some people. It's the evidence in the case that you'll be presented with. Knowing that, does that cause anyone concerns about your ability to sit on this jury and weigh that evidence with all the other evidence and just give it the weight you think it's due? And juror 1330, I think that maybe was from you. Talk to me a little bit about that, if you're willing.
I feel like I can say that I would be fine. I think I could tell myself that I would be fine until I saw it. And as a mother, I might not be able to see.
So I don't want to put you too much on the spot, but I just want to talk to you a little bit more about that. So if you were given an instruction by the judge that you're to view all the evidence, give it the weight you think it's due, do you think viewing those type of images would have such an effect on you that you couldn't be fair and impartial and weigh the evidence, the other evidence?
No.
You think you would be able to view it, even though it might be upsetting?
Be impartial, absolutely. But could I look at it? Difficult.
And when you say difficult to look at it, if if you knew you had to view all the evidence, do you think, even though it might be disturbing, which is normal, do you think you would be able to view it and then just give it the weight you think it's due in relation to all the other evidence you may see or hear?
Yes.
Thank you for that. And juror 977, I think you also are a mother. Does that cause you any concern about your ability to be able to view those images? Do you think that if shown them, even if they were upsetting to you, do you think you would be able to just weigh them and give them the evidence or the weight you think they're due in relation to all the other evidence that you may see or hear? Nothing about them would automatically make you form an opinion just based on those alone. Thank you for that. And juror 1288, I apologize. I think I missed a hand from you, so I'm sorry about that. Can you talk to me a little bit about your thoughts on that?
Yeah, I have two very young children. It would be very difficult for me to see that.
And kind of same line of questioning, while it might be difficult and it might be upsetting, do you think you would be able to view those images and give them the weight you think they're due in relation to any other and all other evidence presented in the case?
I think I would be able to, yes.
And I know there was a little bit of hesitation there, so I'm just going to follow up a little bit. If you looked at those images, do you think it would automatically cause you to form an opinion of guilt or innocence, or do you think you'd be able to just view it and wait until it's time to deliberate and form that opinion?
I think I would struggle to not make an immediate.
And when we talk about an immediate opinion, do you think you would automatically attribute the images to the defendant and hold them against him? Or would you be willing to listen to all the evidence and make that determination?
I would be willing to listen, but I worry truthfully that I could be partial at proceedings.
I may have just a moment, Your Honor.
Yes.
And juror 1288, we may follow up with you a little bit more in the individual, if you'll still bear with us and hang in there for this process. Thank you. So I also have a little kid, and in the mornings when he gets up, if I ask him, what do you want for breakfast? 9 times out of 10, it's cheesy eggs. And there is a very specific recipe that he likes me to follow. So it's the eggs and the milk and the cheese and salt and pepper. And if I modify it, he might get upset with me. He might refuse to eat it. Sometimes he might want some extra cheese and I'll do that for him. Do any of you have someone in your life like that, whether a kid or an adult you know that maybe has a specific recipe they like done just a certain way?
Yes.
And juror 1436, I think you had said yes. Can you tell me a little bit about that?
Well, I have 2 kids. I'm pretty picky. And they want things a certain way. And if it's not made that way, then they don't want to eat it. So.
And oftentimes, are you willing to do it the way they want?
Majority, yeah.
Do you sometimes modify it?
Yes.
Fair enough. And juror 1185, how about you?
He's a pretty picky guy. Really like any seasoning or anything, so if I try and do anything too special.
I'm having a little trouble hearing. So
My son.
After I don't believe. I got to.
I'll just repeat. So my son's pretty picky. If I try and add any like spices or anything to his food, which I'm always trying to do because I'm a chef, but he won't eat it.
And I noticed you were a chef, so I kind of wondered about that. So you deal with recipes a lot.
Yes.
And in your line of work, do you sometimes modify them?
Only if you have to.
So at times, do you just follow the recipe as is?
Yes.
And why do you do that?
Because it's what works.
And someone else has either determined that or you've maybe created the recipe yourself?
Yes.
And you know that's what works. So in this case, because in our everyday lives, sometimes we might modify things a little bit. We may look at a recipe and say, I'm gonna add or subtract this, I'm gonna do it a little bit different. But again, we've talked about the jury instructions. The judge is gonna give you very specific jury instructions. And in this situation, you won't be able to modify those. So it'll be whatever the judge instructs. That's it, that's the law, that's what you follow. And that will include some instructions regarding these particular crimes and what elements are required to be proven. So in that, kind of like ingredients in a recipe, the judge will outline what is necessary. Sometimes you might look at that and think, man, I really wish this element makes no sense to me. Why do they have to prove this? Or you may think, well, they should also have to prove this. This doesn't make any sense. But you don't get to modify it here. Does anyone have concerns about their ability to follow the instructions as given by the court? No. And one of, or some of the charges here deal with the crime of homicide. And you'll be given an instruction, and again, it's what's given by the judge that'll be what matters. But it will include something along the lines of that the individual was involved, that the defendant engaged in conduct which caused the death of a person. So that'll be one of the elements. What you won't see is there will not be an element that says the state has to prove what the cause was. So it'll say we have to prove someone did it, but we don't have to prove how they did it necessarily. Or we don't have to prove why the person actually died, what was the cause. Does anyone have concerns that if the state is able to prove that a murder happened, will anyone be thinking that the court should have added that element? Or will everyone be able to follow the court's instruction as given?
Yes.
Follow the instruction as given? Does that cause anyone concern sitting here today? Thank you. Anyone here an NFL fan? I see some nods, so we got quite a few. Juror 1271, you nodded your head. Yep. So Kansas City Chiefs won this year. You don't have to tell me how you feel about it. You can if you want. Okay. So knowing that, and even with that, would you agree that every person on the Kansas City Chief team should get a Super Bowl ring?
Yes.
And that could include, and so even if the quarterback played a bigger role, do you think the punter should still get a ring? And the second string, even if they didn't play on the field? And why do you think that?
In my experience from growing up playing sports to my career now, is that sometimes the most underrepresented individual within that group actually is overwhelmingly a reason why there's a success to a plan being whatever that is, and it's not the one that's always sitting behind the camera. So it's very obvious to me that everyone should, right, for that reason. So you don't understand what really happens behind the scenes.
All right, thank you for that. And juror 1503, how about you? What do you think? Should everyone get the ring? And why do you think?
Well, I play soccer, I like team sports, so I think it's a collective effort to win and lose. So, yeah. So yeah, that everyone equally participates in that.
And I appreciate those answers and thanks for the involvement. You heard the judge start to give an instruction regarding conspiracy, or he did give you an instruction regarding conspiracy. And he talked about it being an agreement by 2 or more persons to commit a crime. And the actual instruction he gave talked about that you're not to consider Lori Vallow Daybell or Alex Cox's guilt or anything that may be going on with their cases. And we all understand that. Everyone's in agreement that they'll follow that instruction.
Yes.
What you will hear about in this trial, though, are some actions that are alleged to have been taken by Lori Vallow Daybell and actions that have been taken by Alex Cox. And remember, a conspiracy is an agreement between 2 or more persons to commit a crime. An additional element is that then just one of those persons has to do an act in furtherance of the conspiracy. So just one person has to take an action that gets them closer to committing that crime. So if you were to hear evidence that there's you know, A, B, and C involved in a conspiracy, A, B, and C reach an agreement, and you think the state has proven that there's an agreement to meet a crime. And you think the state proves that all the individuals or the particular individuals involved wanted to commit that crime, wanted that crime to happen. And the state only shows that, say, person C did an act in furtherance. If given jury instructions describing conspiracy that way, would you be able to still hold person A or B accountable for the actions of person C, given that there had to be the agreement and just one person had to do something in furtherance?
No.
You wouldn't be able to? And that's juror 1353. So let's talk a little bit about that. What's your concern with that?
I think everybody should be responsible for their actions. You can talk about doing something, but doing it is completely different. So you're responsible for what you do, not for what you talk about.
And if you're told that conspiracy involves reaching an agreement, so we're talking about people meeting and agreeing to commit a crime, does that change anything for you that there's that agreement, that we're required to prove there's an agreement?
No, they have to do it. They have to commit the crime.
And if you were given a jury instruction that said, this is what conspiracy is, and you just have to find one person did an act in furtherance, would you find that hard or impossible to follow that jury instruction?
It would be impossible.
Your Honor, given that, the state would make a motion to excuse juror 1353 for cause.
Judge, can we approach?
Yes.
instruction that says, Mr. Daybell or Chad doesn't have to take the stand and you can't hold it against him. Will you folks follow that and agree to follow that?
Yeah.
Thank you. The other thing is that he doesn't have to present any evidence. If he decides not to present a single shred of evidence, he doesn't have to do that. He doesn't have to say anything. He doesn't have to do anything. And if the state doesn't meet their burden and in some way falls short, does everybody understand that the verdict needs to be not guilty?
Yes.
Okay, okay. I want to go back a little bit to what Ms. Blake talked about in terms of an agreement. Does everybody understand what the word agreement means? You sure if you all understand what agreement means? And I'm going to, I left it over here, excuse me. I'm going to go to 1577 and I want you to ask or tell me what you think an agreement is.
Agreement to me is two people.
Well, let's make it easy. Does it have to be in writing?
No.
Does anybody believe an agreement has to be in writing? Can it be done verbally?
Yes.
Okay, so there has to be some sort of verbal statement to each other and say, we have an agreement, right? And shake on it. Is that fair?
Yeah.
Does anybody disagree with that? Anybody? You are, okay.
Yeah.
Well, I'm gonna go down here first because I haven't heard from 1537, so go ahead.
I don't think you need to shake on it.
Okay. Okay, verbally, you have to sort of speak the magical words. Would you agree with that?
Yeah.
Okay, and then 1353. Yes. What do you think about that?
Well, it's like in marriage, you say I do, but you also have a signed marriage license. So there's a legal document there. It says that you're married. You
Okay.
can't just say, I love you and I marry you and be married. It doesn't work like that.
So if you beat around the bush and say, I kind of like you, and, I wouldn't mind spending some time with you, and just make general representations about things. But, it's not particularly clear that you said, I do. Should somebody force them and say, well, you said I do, so you're married? Is that fair?
No.
So just beating around the bush and everything else, that's not really an agreement, is it? No, when it comes to marriage or anything else, right?
No, it's an opinion.
At 1185, you're shaking your head. Do you agree with that? Oh, I'm sorry. You're shaking your head. So I'm going to go to 1219. I want to hear your thoughts on what you think is necessary for an agreement.
Well, I have an interesting example.
Okay.
I agreed to sell my father a gun.
Okay.
Over the phone, and later on found out it was worth a lot more. Then I backed out. We haven't spoken since.
Okay.
So he thought that was an agreement, and I honestly entered into it as an agreement.
Okay.
And then found out some more evidence, changed my mind and backed out.
Okay. So let me ask you this. What if he had just said to you, we're going to get back to the marriage thing too, because that's actually a really great example. But what if he had said to you, and what kind of gun are we talking?
Just a gallery gun.
Okay.
.22 Magnum.
Okay. Okay. What if he had just said to you, boy, I like that Magnum. And you said, I bet you do like it. In fact, it's black. It shoots straight all the time. And I've never had it fail on me. Do you guys have an agreement to sell that gun?
No.
Why?
It's really hard for me to answer.
All right, well, is it possible that you didn't come to eye and say, yeah, we've joined in this and we're gonna be doing this together?
In this particular case, the the value of the gun changed
Right.
from what we thought it was.
But leaving that aside, I'm just talking in general, talking about it. Just saying, you know, that's a black gun. It's always shoot straight for me. And there was never any discussion specifically about buying it or selling it. Just describing the gun, talking about the subject, discussing the topic.
No,
Is that an
that's not
agreement? Okay, 1503. Is that an agreement? I am blessed, and she's, you know, well, maybe I shouldn't say that. I am a lucky man. I have an absolutely gorgeous girlfriend. Okay, beautiful girlfriend. And this is gonna kick back at me. I know it's coming. And I think dearly of her. And I don't deserve her. And I don't know whether she would marry me or not, but we skirt around the issue a little bit. I really care for you. I like spending time with you. I see a future with you. An amazing cook. And we talk about a lot of things, and we love to cook together. And we talk about a future down the line, possibly, you know, wanting to spend our lives together. I want to see the hands. If I made an offer of marriage to her, anybody think I made an offer of marriage to her, would you please raise your hand? Then I want to identify you because she may get a hold of you and say, see, he told you all these things. But nobody believes that that's an offer of marriage, is it? Or an agreement, right? And even though it was verbal, there still needs to be more than just talking about the subject, doesn't there? Yes. Okay, thank you. I think I want to move on a little bit. Have any of you made major decisions in your life that you really had to think about? Yes. Buying a house. Anybody buy a house? Okay. Buying an expensive car. Anybody? Things like that. Is that a recipe you follow to make a major decision in your life? No? Because you're the chef. And have you bought a house? Okay, have you bought an expensive car? Yeah. But I bet you bought some very expensive equipment to cook your food with. Well, I mean. Now, is there a recipe when you're going to buy that software or cookware and all of that stuff?
That's more of a method.
Right, okay. But it's not a recipe that you knock, check boxes off and go down the line. Yes, it's not.
Like 1 cup of flour.
Right, right. So when we're talking about a case like this, and Judge Boyce instructed us a little bit about this. And he said, you know, you're going to look at the facts and the evidence. Okay? Does anybody understand what facts and evidence are? Everybody understands that, right? Yes. Yeah. The pen is blue. The car is red. And you're going to hear facts. And you're going to hear evidence. But do you think, as part of making a decision, you should guess about some of the things? Is guessing involved when you're making a serious decision? And I just saw the shaking of the head, and I want to say it's 1436. Yes. Guessing is not part of it, is it?
No, not at all.
And the word speculate. Do you think you should speculate when you're making a big decision about something?
No, no,
Ever?
no.
And I want to move and talk to some other people because I don't want to feel like anybody's getting ignored here. So we'll go to 1382. What about this idea of speculation? Should we speculate about things when we're making a major decision? Should we guess? What about using a hunch? Saying, you know, I'm going to use a hunch and kind of figure out what really is going on here. Is that fair? Okay. Can all of you commit that if you're chosen as jurors, that you're not going to speculate, make a hunch, or guess, and that all you're going to do is apply the facts and the evidence to the case? Can all of you raise your hand and promise, no, strike that, commit to me that you're going to do that? Can all of you commit to me that you're going to do that? Raise your hand, can I see them? Please, all of you, thank you. Okay. There are circumstances, and I guess I want to talk to you a little bit about this. Is there anyone in the jury pool who has been honest 100% of the time in their life and have never told a white lie, a fib, or anything like that? Please show me, because I'd like to see one for the first time in 30 years. Nobody. I'm sorry. People tell untruth. They tell lies sometimes, white lies, big lies, things like that, right? Yes. What do you think some of the big things are that people lie about? Let's go to 1353 again. Ooh. How about relationships? People lie in relationships.
Absolutely.
Okay, let's go to 1366. People lie in relationships?
Yes.
Okay. 1288, people lie in relationships?
Yes.
Okay. Let's say that, and it's not me, that somebody goes out after dinner and has a few drinks and is with somebody that they shouldn't be. And they get home and their wife goes, where were you? Oh, I was at work. Maybe they weren't at work and doing something else. Is that a situation where you would tell the truth and say, this is where I was, this is what I was doing? Or do you think there's a chance there might be a lie going on there? Pretty good chance someone's going to lie about that, right? And people lie about relationships, they lie about business, right? Okay.
Yes.
Okay, and they do that to sort of, nobody wants to find out that your wife or husband has something going on behind you. You would lie about that, right?
Yes.
Okay. There's an expression, and I tell some of the other jurors, and I don't know how they're taking this, but I listen to a wide variety of music because I'm old. I think I'm probably older than everybody in the jury. Pretty sure I am. All of you. Some of you have got a lot of years on. And I'm a child, unfortunately, of the 70s, which means there was disco music. And if you know anything about exactly. And I didn't wear bell bottoms, I promise. Not a bell bottom guy. But I've listened to a lot of variety, a lot of music and different kinds of music. But I enjoy country music. It's just something that I enjoy. And there's a song that the title of the song is "Everything That Glitters Is Not Gold." And it talks about the interaction between a man and a woman. And I'd like to see if any of you can guess what you think that expression means. Anybody have any ideas about that? Anybody? Nobody wants to jump up. Go ahead. It's number
1271.
1271. You're right. I'm sorry.
I think probably in reference to that song, it's just because something makes you feel good or has that attraction to it. It's not always good for you. Be what I would say. Nothing else.
And I go back and I think about this all the time. And where does the song take me? Many years ago, there was a very wealthy man who was about 92 years old. He was a millionaire. And he decided he just had to marry this 18-year-old girl. And it caused a lot of problems down the line, but he went into the marriage. And I think of that because I think, the 18-year-old girl glitters. Beautiful, wonderful. But how long did it take them to figure out that everything that glitters is not gold? And another situation is like this. Have any of you been in a job that you thought was going to be a great job? And then all of a sudden you got into the job and you realize, oh my gosh, I left my other job and now look what I've got. This blanks. Anybody been there? Anybody? No? None of you have ever had a job where you, go ahead. No, actually, we'll start with him and then we'll get to you. Go ahead, juror number 1288.
Yeah, just getting to a job where it was certain tasks or income was promised that sounded a lot better than it looks when you're doing the task.
And everything that glitters is not gold. And the difficulty is if you invest or you spend the time and go down that road and then suddenly realize, oh my, this isn't what I thought it was, and maybe you didn't have all the facts, and then I've been there. Anybody else? Juror number 1271, excuse me.
Yeah, kind of obviously same, except for everything that was promised, but you figured out that the people, the personnel around, it's not like a good spot to work, you know, so again, having that regret, you know, nothing was misconstrued, still you realize like this is what I wanted to be, what I thought it was gonna be.
Or it could be worse than that. You meet somebody and you realize, oh boy, it's too late now. Look what I got stuck with. What is going on here? And juror number 977, you're very quiet, but you had made eye contact with me and it looked like you wanted to say something. Nothing? Don't want to say anything. Okay.
While you're talking.
Okay. Okay. I'm going to go into the last subject and then I'm done. Okay? It's about time, right? It's about time. Ms. Blake talked a little bit about this. And I just want some comments on this, and I appreciate juror number 1330 to talk about this a little bit. I'm going to see if some of the other folks will discuss it a little bit as well. You're going to see graphic pictures. You're going to see very, very graphic pictures. And these pictures are going to hurt your heart. I am telling you, they're going to hurt your heart. They hurt my heart. And I want to make sure that when you look at these pictures, that the immediate reaction is not to take it out on him. Can everybody at least commit to not taking it out on Chad when you look at these graphic pictures? Yes. Would you please just put your cards up or your hands up so I can see that? Thank you. No, I didn't see it. We see that a lot of instances where media outlets, TV shows, podcasts, all of these people throw these graphic images up on the screen to make a statement. Has everybody experienced that? And the point of it is to get a reaction from you. The point of it is to cause you to become upset, and then you do something. Would everybody agree with that? But until you've heard all of the evidence and made a decision about the case, would it be fair to look at these heartbreaking images and hold them against Chad until you've heard everything that's been said? Would that be fair? It would be fair to hold it against him? Everybody agree that no, it would not be fair to hold it against him? Yes. Folks, I want to thank you. I want to appreciate the time. I appreciate you being very straightforward. This has been very easy for me with you folks. You're extremely easy to talk to, and I want to thank you for that. Judge, that's all I have at this point. Thank you very much, folks. I appreciate it.
All right. Thank you, Mr. Pryor. At this time, then, that concludes the group section of this voir dire. We are going to talk to each one of you individually, also the presence of the other jurors. So at this point, we will begin with our lowest numbered juror first, which would be juror 977. If you could remain, we'll have the other jurors excused to the jury room and brought back in one by one. Please. Thank you. Please be seated. All right, 0977, you're not in trouble. We're doing this with everyone.
Yeah.
We wanted to discuss different topics that are best discussed outside of the presence of other jurors. And in this case, let me just take a brief moment to review your questionnaire. You talked somewhat in your questionnaire about potentially having a hardship based on the age of your children, and you didn't, however, I think, raise your card when we went through that earlier. Could you just describe if you think you are able to serve for this time period, given your obligations?
I just wanted to be honest. I mean, it would be extremely difficult, but I mean, we could potentially make it work. If it came to the needs of that, I guess. I was just being honest. We can find childcare, but we also own a business, so it would be extremely difficult, but I wouldn't say it would be impossible. So I was just trying to be honest about that.
So you're basically self-employed?
Yeah. My husband and I own an insurance business.
Okay, how involved are you in the day-to-day affairs of the business?
Very involved.
If you were required to serve for this time frame, with both thinking about your children as well as the business, do you think that could become a distraction, or would you be able to set that aside and focus on evidence here? And I would note, it would take up the majority of your time, or nearly all of it, and energy mentally. However, we do intend to stop each day at 3:30 in the afternoon, which would give you some time during the days when you're not sequestered. I'll also mention there may well be a time when you would be required to be sequestered, and so you simply wouldn't be available to be with your family for a week or 2 weeks potentially. So given all that, I'll just allow if the state and defense would like to question her in relation to a potential hardship, and then we'll move on to some other issues to discuss.
Your Honor, as to hardship, we don't have any questions.
Prior.
When you talk about daycare, in addition to removing one of the two salaries in your family house by you being gone, you're gonna have to pay for that daycare.
No.
You know, so there won't be a cost for you to pay for daycare?
There won't be a cost, but we would lose income because we would lose an employee, which is difficult. My husband would have to do my work.
Well, would you also be taking care of the daycare as well?
No, we would be putting that burden on my in-laws on top of what they already do.
Okay, so you're gonna be placing a burden on them, but there's gonna be a loss of income.
And I'm sorry, but talking about being sequestered and becoming a distraction, that would definitely become a distraction. That would become the case for more than a day or two.
Okay, and it would almost surely be more than a day or two.
I guess I might be kind of confused about that. As far as like being away, as far as not being able to go back to our home for more than a week or two.
All right, and counsel, I don't want to necessarily reveal more personal information than necessary, other than indicating very young children involved here with this family.
Judge, I intend to make a motion.
Go ahead, Mr. Pryor.
Judge, I'm gonna move to exclude, they are very young children, and they need to be away from children of that age for more than a day or 2 days, I view as a hardship. So I would move to exclude this juror on the basis of hardship.
Response from the state.
Your Honor, I'm not certain that I've heard from the juror that she views that aspect of the hardship. I think we've heard that it's important for her to be with her family and her children. But to me, from the juror's last comment, she doesn't really understand the potential expectation of sequestration. And so I'm not sure, based on what the defense's motion was that there's grounds to excuse her for hardship just because her children happen to be 1 and 3 years old.
All right, Mr. Wixom. The questionnaire did state you would have a hardship, and I guess I just want to ask you that then, knowing that that is a very likely possibility or real possibility that would occur in this case where you would be sequestered away from your family for some time. How do you think that would impact you and your ability to focus solely on determining this case?
It would impact me greatly.
In what way?
Thank you.
Cause you to be distracted from focusing on the evidence and the law here?
Yes, if I'm away from my family for more than, 8 to 3, 30, I believe, longer on some days, then yes, it would impact me.
Okay, and I'm talking about that sequestration time if it was two straight weeks.
Yes.
I am going to sustain the challenge based on a hardship for juror 977. And I do very much appreciate your willingness to try to make these arrangements and accommodations. This is an unusually long and complex trial. So not all are like this. And thank you so much for taking the time to accurately fill out your questionnaire, return today, and provide these candid responses to the court. All right, thank you. You can be excused. Council, at some point, I've got to address a couple of concerns with our jury commissioner briefly, but we would do that during a break. We're in this individual section and we've got a ways to go. Is this a logical time maybe for a mid-afternoon break?
The state believes it will be, Your Honor. Thank you.
Very well. We'll take a break right now. We'll advise the jurors also that we're on break and then we'll come back on continuing this juror number 1185.
All right, please.
All right, we're back on the record after our mid-afternoon break. KCR 2221-1623, State of Idaho versus Chad Daybell, conducting individual voir dire of these jurors, and our next juror to be brought in will be juror number 1185. All right, juror number 1185 is returned, and upon review of this questionnaire, I don't know if there's any further follow-up or dire needed on case knowledge, bias, or hardship. Is the state intended question on any of those areas?
I actually just have one one area of questioning just on one of the standard of proof questions, if that's all right, Your Honor.
Okay, why don't you start there with your inquiry? The court doesn't have any of my own voir dire at this point.
Thank you so much, Your Honor. Good afternoon. On page 8 of your questionnaire, if you could turn to it really quick, just so you can refer to it. It's question 2, subsection C. You had checked yes, that you feel that the burden of proof should be higher than proof beyond a reasonable doubt. And you had checked yes. If the judge provides you an instruction, well, actually, before I go there, could you kind of explain your thoughts on that?
Yes, so at first I'd like to say I filled this out with, after working all night and I may have had zero sleep.
Yes.
So let's see what I wrote here.
Yeah, take a moment if you need to, sir. That's totally fine. And there's no right or wrong answers. We're just kind of trying to gauge your thoughts on this stuff.
Yeah, I think that, you know, with this kind of thing, the proof should be beyond, like, look, absolutely certain.
Absolutely certain.
Absolutely certain.
So if you were to receive an instruction that said proof beyond a reasonable doubt is not a possible doubt or an imaginary doubt, was that something that you'd struggle with if you want absolute certainty?
Perhaps, yes.
Okay. Sir, so did you have anything to add to that?
Oh, no.
Okay. So if I'm understanding correctly, you hold a conviction that proof should be beyond any possible doubt whatsoever.
Yes.
And if I'm understanding you correctly, you'd have a difficult time following the judge's instruction if the instruction was proof beyond a reasonable doubt is not a possible doubt or an imaginary doubt. Is that fair to say?
So like, sorry,
It's okay. It's totally okay. It's totally okay.
I'm not sure I'm just fully understanding. But,
Okay, so let me ask you this. Are you saying that, well, let me ask you a different question. Even if you held a personal belief that there should be proof beyond any and all doubt, not even like even proof beyond even a possible doubt, proof beyond even an imaginary doubt, would you struggle to follow an instruction that was different than that?
No.
Okay, I have no additional questions, Your Honor.
No questions, Judge.
Okay. And I do want to just be clear on that point then, for this juror. I did, in the beginning of what I was going through today with you, read an instruction, and it is the instruction that you would be given in this case. I just want to read that instruction again about what reasonable doubt, how it's defined in this case. And the instruction reads as follows. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. And that's the definition part of that. Would you be willing to follow an instruction that is the standard you're to apply to the evidence in this case?
Yes, so using real tangible things.
Just that instruction, and that again is the definition, and you would be able to follow that instruction?
Yes.
Okay, I don't have a further question on that topic. Anything further from either side on that? All right, at this time then, without additional board hour on that, let's next take a look at the section of your questionnaire that is your attitudes regarding the death penalty, and where you've indicated you were operating on little sleep when you filled this out. If you don't mind turning to page 12 of your questionnaire. And so when you filled that out, you were just asking your opinions and attitude. Now that you are a prospective juror in this case, I'm going to advise you that it may in fact be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. And when you're considering that, you have to consider that it, as it should be done, any penalty you are considering should be considered as if it is absolute and would be carried out in the case. So with that context in mind, in your answers you stated right in the middle of that page 12, the question, do you support or oppose the death penalty? You said you would support. Is that the way you feel here today?
Yes.
Okay. If you please look then at page 13. You had a set of choices, 7, to accurately describe the way you feel about the death penalty. There's a mark there, I think closest to C. Am I to interpret that as C being your choice?
Yes.
Okay. C is a statement that says, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that the way you would feel about the death penalty still here today?
Yes.
All right. Are you in favor of the death penalty in every case where a murder has been committed?
No.
Okay, just one final question from me then. Are any views you have on the death penalty going to prevent or substantially impair you and your ability to be a juror in this case and to follow the court's instructions relating to the death penalty?
No.
Okay, that concludes my board diary on that topic. Does the state have a board diary?
No, I don't. Thank you, sir.
Any board diary from the defense?
No, Judge.
Okay, juror number 1185, that concludes your individual board diary. I'll have you return to the jury room with the bailiff. Thank you. We'll next talk to juror 1219. Will either counsel have an inquiry for 1219 on hardship or bias?
The state will, Your Honor. No, Judge.
Okay, thank you.
Judge, can I have just a minute? For some reason, it's not letting me back.
Yes,
May I have a moment for that?
yes.
Yes. It's not.
It's, I mean, it's a large amount.
Got it, Judge. Thank you.
Okay, thank you. And we'll have juror 1219 brought in. All right, juror 1219 has returned. We have some additional questioning for you outside the presence of the other jurors. I believe you've got a copy of the questionnaire you filled out. If you do, would you please turn to page 12 of that? And that is the section of the questionnaire discussing your attitudes regarding the death penalty. When you filled out your questionnaire last week, do you recall thinking through these questions on the death penalty and providing these answers?
Yes.
I'm going to advise you in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And when you consider it, consider that it should be done as if it is absolute and will be carried out in the case. When you're thinking about these responses. Knowing that, and with the time that's passed since last week, is there any change or amendment you would have to those answers, or would they still be true and accurate today?
No changes.
Okay. On page 12, you had a choice of do you support or oppose the death penalty, and you said support. Is that still your position here today?
Yes.
If you would please turn to page 13. On that page, you had a set of choices that describe the way you feel and what's most accurate. You picked C. C reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the way you feel about the death penalty?
Yes.
And you would be willing to follow any instructions about it in this case?
Yes.
All right, the next question I'll have then is, are you in favor of the death penalty in every case where a murder has been committed?
No.
Okay, and finally, I'll ask you, is there anything you think or we should know about your views on the death penalty that could prevent or substantially impair your ability to serve as a juror in this case and follow the court's instructions about the death penalty? All right, that concludes the voir dire of the court on that topic. Does the state have any voir dire?
The state has no questions, Your Honor. No questions, Judge.
All right, juror 1219, that concludes our individual voir dire with you. If you'd please return to the jury room with the bailiff, we'll call in another juror and let you know what's happening once we return you.
Thank you.
1271 will be up next. I know there was some tech issue here. Are the parties able to access that questionnaire? All right. So I don't know if it was advised with 1271. Okay, thank you. All right, juror number 1271 has returned for additional individual voir dire questioning. I'd note that this juror does have some case information and raised their card when asked if they did know something about the case. So we'll discuss that, and you can certainly openly discuss any facts you know about that here with the other jurors not present. There wasn't any indication that there may be a hardship, so I don't have any of my own voir dire in terms of bias. I'll allow the state to ask any questions about that, followed by the defense. So we'll do that for the state.
I will, Your Honor.
Go ahead, Mr. Wicks.
Thank you. Sir, in reference to what the court had just said, you had made some early responses that you do have some case information. Can you just kind of give us a nutshell of what you understand about this case before you came here?
Yeah, and I didn't know if it was the right time to ask the question, but I assume most people have some. That was kind of my take with it, is that I've just heard news clips, stuff like that. I know there was, I've heard Lori Fallow, but the other person that you guys maybe mentioned was possibly a conspiracy. I don't know that name. I've seen a lot of like just news clips that have popped up on it.
On that point, I understood you said you didn't know this other person. Did you see or learn enough that you even remember the names of the victims, the alleged victims?
It kind of rings a bell when I hear it, but I couldn't listen right now. I know that it's 2 kids. I know that just like random little tidbits that maybe Hawaii was in part of it or something like that, but not like I don't know a ton of details about the case. It's just I obviously have, sometimes sit and see news clips and stuff like that.
Did you happen to watch any documentaries like Netflix or
No.
anything like that?
No, no, it was just like, it was just news clips that, you know, it was obviously a long time that the span was unfolding, so it was just constantly here, like, someone's maybe saying something like, oh, did you hear about that? And that's about it, I just don't know a ton of details.
Do you feel, based on whatever you did gather from what you're referencing, do you feel like you could set aside anything that you have learned and freely listen to evidence as it comes in and then be impartial in rendering whatever decision you might make as a juror?
Absolutely, like I said, I don't know enough to even be like, really put a stance on. So, yeah.
Okay. The last question on this, on your questionnaire on page 19, you had noted, I don't know enough of what happened to form any ideas, and I also believe in innocence until proven guilty. What did you mean by that?
Just the fact that even, you know, hearing it, I'm a firm believer in the fact that, you know, like, I'm just listening to random clips, like, you really don't know the whole story until you sit down and go through it. It's just, that's all I was saying. That's the little bit that I have heard absolutely doesn't really matter until you sit down.
So is it fair enough to say that you're going to presume his innocence until the state proves him guilty?
Absolutely.
Thank you. No, I don't have any more questions.
All right.
Questions, Judge?
Okay. The next issue we'll discuss then, juror number 1271, relates to your attitudes regarding the death penalty. If you do have a copy of your questionnaire there, this is on page 12 and 13 where we're looking. And I am going to advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. So thinking about that, you did provide answers here. Do you believe the answers you provided are still accurate in the way you feel here today?
Yes, yes.
Okay, absolutely. You were asked if you support or oppose the death penalty on page 12. You said you support it. Is that still the way you feel?
Yes.
Okay, on page 13, there was a series of choices, 7, that go into some more detail about what you think most accurately represents the way you feel. And you selected option C, which says, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still representative of how you feel about the death penalty today?
It is.
Are you in favor of the death penalty in every case where a murder has been committed?
No, I'm not.
All right, and finally then, is there anything about your views or beliefs in reference to the death penalty that you think could prevent or substantially impair your ability to serve as a juror in this case and follow the court's instructions?
No. No.
Okay, thank you for your responses. Does the state have any more, Dyer?
We do not, Your Honor.
Nothing, Judge.
All right, that concludes the voir dire. Juror number 1271. We'll have you return to the jury room and the bailiff will give you further instructions. Next up will be juror 1288. And we'll have them brought in. Does counsel intend any voir dire in this one in relation to hardship or bias?
Yes, Your Honor. This is a juror that we'd left off some questioning to pick up again during individual.
Okay. Oh, correct. Thank you. All right, juror number 1288, thank you for returning. We are reviewing your questionnaire here. There were some concerns raised in the group voir dire that the state's going to ask about. In addition, if there's any other questions that could relate to a hardship, you can inquire there as well. The state can conduct individual voir dire with this juror than the defense. Ms. Blake, is that you?
Yes, Your Honor.
Go ahead.
Thank you. Juror 1288, thanks for sticking with us. I know we'd had a conversation about graphic images and I said, maybe we'll pick it up in individual. So that's where I wanted to start with you. I know I kind of had put you on the spot and you may or may not have thought too much about it before coming in today. But I believe where we left off, and correct me if I'm wrong, but I think you did have concerns about your ability to view any images of that nature that you may have a reaction to, and then just weigh them in relation to other evidence. You probably had a little more time to think about it. Do you still have that concern?
I think I'm concerned about it. I think I want to be impartial and weigh it accurately. I do think I would struggle in associating that with my own personal situation. So that's.
I think we did talk about, and I won't get into specifics, but we did talk about you have some children. Do you think, because you've said you want to be impartial though, and obviously as you look at evidence and give it the weight you think it's due, you may weigh that out how you feel appropriate. Do you feel like something about seeing those images would make you automatically impugn guilt to the defendant without having heard before you've heard all the evidence and weighed it out? Would you automatically draw that assumption or conclusion, do you think?
I don't know if I would automatically assign guilt, but I think I would. Where I'd be a little emotional in my wanting to seek justice.
And that's fair. Do you think if instructed by the judge that you were to wait to form any opinion until having heard all the evidence and in reaching your conclusion, do you think you would be able to, even though you may have an emotional reaction, which is normal, do you think you would still be able to follow the court's instruction and wait until the end to make that final decision for yourself?
Yes. Yeah.
Thank you. I don't have any additional questions on this.
All right, thank you. Mr. Pryor?
I guess I just want to clarify.
Microphone, Mr. Pryor?
I'd like to clarify a little bit if you don't mind. You see some graphic pictures, and I talked about that a little bit. You're going to have to block out having some sort of reaction and putting the blame on Chad. Is that what I'm hearing?
That I would have to block it out, is that right? Yes.
So in other words, you would be predisposed, or bad word, you would be upfront. If you saw these pictures, you would instantly say, you know, I want to blame him for this. But you'd have to stop yourself and wait until you saw the rest of the evidence. Is that what you're saying?
I'm saying it would be difficult for me to not make an immediate emotional reaction of wanting to assign guilt to somebody.
And that's what, and again, I want to remind you, there's no wrong or right answer here. Because I really appreciate your honesty. I'm grateful that you're being honest. And so I'll restate what I said. You would have and I don't want to say extremely, but you would have a very difficult time not assigning guilt to somebody after looking at those pictures, and it would have an impact on you while you were deliberating. Is that fair?
I think so, yes.
And don't take this personally, sir. No, please don't. Judge, I'm going to move for cause on this. I'm worried about potential risk here.
All right, response from the state.
Your Honor, the state would submit to the court on this one.
All right, well, this is why we conduct these sometimes individually. Juror 1288, a few of those responses by sharing a concern of the defense that this is evidence that's likely to be admitted in the trial that may affect you in a particular way to shift a burden away from the defendant to which he's entitled. And so I appreciate you really thinking through. I can tell you very carefully considered your responses to these questions and believe that the challenge is best sustained in this point in our interest of trying to obtain the most impartial jury we can. So thank you very much for filling out your questionnaire and returning today. I'm going to sustain the motion to strike, and juror 1288 will be stricken for bias in this case. You can go ahead and go and return your questionnaire to the bailiff, and we'll move on to our next juror. Thank you. Let's talk to 1330. All right, juror 1330 is returned for individual voir dire. Thank you for coming back in. We're reviewing the questionnaire now. And we're going to be asking you about the knowledge you have about this case in addition to possibly other topics. Because the other jurors aren't here, we wish for you to discuss this in as much detail as necessary to tell us what you know. And with that in mind, looking through the questionnaire and that you've acknowledged you have some case knowledge, I'm going to have the state begin with their individual voir dire as to any possible bias, and then we'll move on to the defense. Ms. Beatty.
Thank you, Your Honor.
Go ahead.
Good afternoon, ma'am. Hi. I just have a few quick questions for you about media exposure in this case.
Yeah.
So in your questionnaire, you indicated that you'd come across some news on TikTok, online, but that it just kind of come up. You hadn't sought it out. Is that accurate?
The only one I sought out was the Netflix special.
The Netflix special, okay. And you watched the Netflix special?
About a year ago.
About a year ago, okay.
So it's not completely clear.
Okay. Would you, and this might sound like an odd question, but would you kind of just tell us what you remember about the Netflix special?
I remember there were several suspicious deaths. I remember that seeing aerial footage of presumably the area of land that they were found. I remember seeing the last photo of them alive. That's about it.
And the area of land that they were found, do you know where that was?
Near Idaho Falls, I think, area.
Do you know who owned that property?
My understanding is that it was the defendant.
Okay. So having watched that Netflix special, at the time that you watched it, did it cause you to form any opinions?
Well, I mean, everything you see on TV is formulated and produced for the benefit of the pockets of the people who own the TV.
So.
I understand that. Now, would it sway me? Not necessarily, because they don't really care whether they're telling barely truths, half truths, approximate truth today's kind of thing for the sake of money. I wouldn't say that I'm personally swayed by anything I see online when it's a for-profit situation.
Of course, I certainly appreciate that perspective. I did notice on page 19, when they asked if you could when the questionnaire asked if you would be able to put out of your mind what you had read and heard, you'd initially checked no, but then you crossed it out and wrote yes. Was that something you've been kind of wrestling with a little bit?
No, I totally checked the wrong box.
Oh, okay, all right.
It was one of those where I think I read something and then I checked it and I went, oh, whoops, that's totally the wrong box. So it wasn't a rethink of the same question.
Okay. And I realize this might all sound kind of silly since I'm the prosecutor in this case, but we all have an interest in making sure that Mr. Daybell gets a fair trial.
Correct.
He's innocent until the state proves him guilty.
Yeah.
And so I think thank you, madam. The concern that I guess I'm kind of wrestling with a little bit is, you talked about how emotional it would be to look at some of these photographs.
Yes.
So do you think that it would be very difficult to look at those photographs and still put out of your mind what you saw in that Netflix special?
I'd like to say that I can do that, but I don't think anyone truly knows what they would do until the moment they've seen those pictures.
Okay.
I've never seen pictures that graphic. Most of the stuff I watch is censored to a certain degree.
Okay. Well, thank you.
So you can assume what you might do. And I would think that I would still be partial to do.
Okay.
I like to believe that I would be.
But as you sit here today, you're kind of struggling with that.
You can tell yourself and you can say, you know what, I'm going to remain partial regardless of what I see. But I don't think anybody really knows when something happens to them for the very first time in their life, what the outcome will be.
Thank you so much. Just one moment. And I want to thank you very much for your honest answers. Your Honor, the state, with all due appreciation for this juror's honesty, the state would move to excuse her due to the exposure that she's had in this case.
All right, response from the defense.
And Judge, I've struggled with this because she's been extremely honest. I appreciate how forthright.
I want to be honest.
And you have been, and very forthright, and I've struggled a little bit with this, but in the end, I think, Judge, I agree with the state. I'm worried that those pictures are going to influence you, and I'm not sure I have guarantees that it's not going to be a problem. And considering what's at stake, it bothers me a little bit, but it's nothing personal.
I'd like to say that I know how I would react, but I've never had that happen.
And that's what
You can't know.
Judge, I go along with the motion to strike.
Very well. The court's considered the request to strike juror 1330 on a bias grounds based on previous exposure to case information. On review of the questionnaire, in particular, having viewed the Netflix documentary, which will contain potential evidence that would return in this case, I share that concern of counsel, and so I'll sustain the motion to strike. Juror 1330, thank you so much for coming in and participating in the process. You discharged your service as a juror in this case with the sincere thanks of the court.
You're welcome.
Thank you.
Thank you.
We'll next talk to 1353. All right, juror number 1353 has returned for individual voir dire. There were some issues brought up in terms of voir dire in the group when counsel was discussing the conspiracy charges in this case, and I indicated we delve into that further individually. In addition, in this case, I don't know that this juror had expressed any knowledge of the facts, but there is that issue to go through as well. On a hardship, we didn't really have anything to discuss there. I'll allow the state to proceed with any additional voir dire relating to those questions that came up, and then I'll allow the defense to do their voir dire on that as well.
Thank you, Your Honor. Juror 1353, you remember we were talking about the conspiracy?
Yes.
And so we talked about the judge would give you the recipe or the instructions, and they'd have certain elements. And with conspiracy, the judge had already said conspiracy would be an agreement between two or more persons to commit a crime. Would you have any problem with that?
It would have to be shown, proven, that there was an actual agreement, not just words spoken.
So when you say actual agreement, what would an actual agreement look like to you, if you could describe it?
Transfer of money, an action that would suggest that there was an agreement made.
And if the judge were to give you an instruction that says what agreement is defined as. So again, kind of like a recipe, the judge is going to tell you what an agreement means. So it could be various things and it could be implied. Would you be able to follow that instruction in determining whether or not an agreement had been reached? Would you have concerns with that?
No.
If you're instructed on it?
No.
And then if you felt that the state had in fact met the burden of proving there was an agreement based on the court's instruction of what an agreement is and that that's an element. And then another part of the instruction was that even if just one of those people do an act in furtherance, so one person does something to carry out the crime or to attempt to carry out the crime, would you then be able to say if there was an agreement, you could hold anyone involved in that agreement accountable?
I would have to ask who's on trial. If the person was on trial, there was an agreement, then I would have to agree with somebody that I don't know about and they agree to it. I have no idea. So I'd have to say no.
So, and I guess maybe I can explain it a little bit better. So the judge had talked about a couple other names coming up. So we had the name Lori Daybell and Alex Cox mentioned by the court. And the court said you wouldn't concern yourself with their guilt or innocence or any proceedings that they may or may not have going on. So if you knew you weren't going to consider that and you're only considering the defendant and you felt the state did prove that there was an agreement, but maybe you didn't feel the state proved that the defendant was the one that committed an overt act, but you believed the state met their burden with one of the other alleged co-conspirators, would you be able to follow the jury instruction regarding conspiracy to say if there's an agreement and one of the parties to the agreement commits an overt act, you could find someone guilty?
You have to restate the question because I'm confused. If you're saying that the person that's on trial has agreed to a contract or an oath, then I think we should be concerned about that person. If there were more people that were involved with a conspiracy, their actions should be tried separately. And so I'm always willing to listen to what the court has to say and is in charge, but that's beyond my scope to know and to understand what somebody else's intentions are.
And if you were able to hear evidence regarding some of those other individuals' actions or alleged actions, and you were told you could consider those actions as part of this trial, do you feel you would then be able to consider what actions someone else took in furtherance of the conspiracy?
Once again, I'm confused by the question. Because what I'm saying is, if we have somebody on trial for a crime,
they should be proved guilty or innocent on what they've done. So somebody else talking about doing something or not doing something, notice it can be proven that they actually did that act. And if it's not to be allowed in this courtroom by the court, then that would be thrown out. But if it is allowed, then it's allowed. And if it's allowed by the judge, then I would have to agree that I can listen to that. But if it's not allowed by the judge, then it shouldn't be presented. Does that make sense?
Yes, I think I understand what you're saying.
Okay.
So it sounds like you would be willing to follow the instructions of the court.
Yes.
And if the court allows certain evidence in, you would consider all the evidence that's presented to you in making a determination.
Absolutely.
And so do you believe if you think the state meets a burden of showing there was an agreement, of proving that you could then, if the court told you could consider actions of another individual that may have taken those in furtherance of the conspiracy in reaching a final verdict?
Yes.
I don't have anything additional.
All right, thank you, Ms. Blake. Mr. Pryor.
It really comes down to a simple thing. If the judge gives you instructions, you're going to follow them, aren't you? Yes, sir. Nothing else, Judge. Thank you.
All right, thank you. Without additional voir dire on those topics, then the court's going to move on to the part of your questionnaire that dealt with your attitudes regarding the death penalty. So juror number 1353, do you remember coming in last week and going through that part of your questionnaire?
Yes.
Okay, and for your reference, we're looking at page 12 is that whole section about attitudes regarding the death penalty. I'm going to advise you in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. With that in mind, I'd like to look at your responses, a few of them. You had a choice of do you support or oppose the death penalty, and you said support. Do you recall answering that way?
Yes.
Is that still the way you feel right now?
Yes.
On the next page, you had 7 different choices to select from which one would describe most accurately the way you feel. You selected choice D, which says, I'm generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Is that still the way you feel about the death penalty as well?
Yes.
Okay. Are you in favor of the death penalty in every case where a murder has been committed?
No.
Okay. Is there anything about any of your thoughts or views or feelings about the death penalty that you think could prevent or substantially impair your ability to serve in this case and follow instructions on that?
No, sir.
All right. Thank you so much for your responses. Does the state have any voir dire on that issue?
No, Your Honor, thank you.
Nothing further, Judge. Thank you.
All right, juror 1353, that concludes your individual voir dire. We'll have you return with the bailiff.
Judge, I'm wondering, just to keep the record clear, the state had made a motion to excuse juror 1353 for cause. I think given the additional answers and information provided, the state would withdraw that request.
Very well. Without a challenge, then will be passed for cause. Thank you for clarifying the record, Ms. Blake, and jury, you can return with the bailiff. And while we're waiting for our next juror, which will be 1366, something I hadn't mentioned previously with this group, but the jurors in this group did all return their affirmations, and they were all okay, with the exception of the one we discussed on the record previously. Those will be contained in the case. All right, juror number 1366, thank you for returning. We do have some individual questioning to take up with you outside the presence of the other jurors. In this particular questionnaire, the court didn't see any concern necessarily of a potential hardship. However, there may be some questions on either side of bias, and so I'll allow board eye on that topic and then move on to our next topic if we're still questioning. So does the state have any questions for this juror in relation to bias?
Just briefly, Your Honor.
Go ahead, Mr. Wood.
Juror 1366, just a reminder, there's no right or wrong answers here. Just tell us what you're thinking, how you're feeling. It sounds like you've seen some media connected to this case. Is that fair?
I've seen headlines.
Headlines. Okay. So have you read articles or?
If I did, it was so long ago, honestly, I don't remember. I just really know from the headlines from living locally.
Yeah. And you did state in your questionnaire that anything you had heard, you'd be able to put out of your mind and render an impartial verdict, correct?
Correct.
And you agree that this defendant has an absolute right to a fair trial?
Yes.
And to start out with a clean slate?
Yes.
And so can you commit to this court, to the state, to the defendant, that you will set aside anything that you have heard and render an impartial verdict based solely on the evidence in this court?
Yes, I can.
State has no further questions, Your Honor.
No questions, Judge.
All right, juror number 1366 then, in addition, there are some questions I'll have about the part of your questionnaire you filled out called attitudes regarding the death penalty. Do you remember when you came in last week and went through this questionnaire, thinking through and answering those questions?
Yes.
All right, the questionnaire then, well, first let me advise you that it may be necessary for you to actually make a determination in this case in regard to the imposition of the death penalty or some other penalty. And so remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. So with that in mind, when you filled out your questionnaire, you had a choice of whether or not you support or oppose the death penalty. You said you support the death penalty. Is that still the way you feel here today?
Yes.
All right, the next question I'll have relates to the choice you made when you had 7 different choices that describe what most accurately represents the way you feel. You circled a selection saying, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the law, by the facts, law, and instructions in the case. Is that the way you still feel about it as you sit here today?
Yes.
All right, so you would follow any instruction the court gives on that topic if that occurs in the case?
Yes.
Are you in favor of the death penalty in every case where a murder's been committed?
No.
Okay, is there anything else to be concerned about in terms of your views on the death penalty and anything you think where your views could substantially impair or prevent you from serving as a juror in this case?
No.
All right, I don't have any additional questions on that with this juror. Does the state have any more dire on the death penalty questions?
No, Your Honor.
No questions, Judge.
Okay, juror number 1366, thank you for returning back. We'll have the bailiff take you back to the jury room while we talk to our other jurors, and then you'll receive further instructions. Next up, 1382. All right, next juror we're going to talk to is juror 1382. This juror did indicate some knowledge of the case through prior media exposure to the case. And we want to talk to you about that. And again, you can discuss that in as much detail as you can so that you know where you stand on those issues without the other jurors here present. And I don't believe the issue of hardship was necessarily before the court at this time. So the state wants to inquire on voir dire and bias. Do that, and who will be doing that?
I will, Your Honor.
Go ahead, Mr. Woods.
Thank you. And again, thank you for being here. And there's no right or wrong answers to the questions we're asking. We just want to get a feel for what your perspectives are. And I want to start just by drawing your attention to page 18 of your questionnaire. And overall, it does not appear like you have a lot of information about the case, but you did indicate some information. Besides Channel 7 News that you mentioned, do you recall seeing any other news reports or documentaries or anything?
I have not. I mean, it's not a recall or a not recall, I have not.
I simply haven't seen that.
I've watched some commercials for Channel 7, so, you know, story coming up at 10. I've gotten some headlines. That's about it.
So then on page 18, you did note, I've seen some Channel 7 news reports years ago regarding the bodies being found and her being arrested. So I'm just going to ask, as you sit there today, from what you can recall or remember, do you remember which bodies and where they were found?
Now, I know that I remember seeing, like you said, the previews to the stories and showing an aerial view of a property. So, no.
So is it fair to say that you don't even remember the names of the alleged victims, if you ever even knew them? Do you recall them as you sit there?
No, but I might be able to. No, I mean, if I sat here long enough, I probably could pick up the names.
Okay.
I don't.
Okay. Well, would it be safe to say that whatever information you did glean from the news over the years, could you set aside anything that you've learned from the news if you're asked to be a juror and just listen to evidence as it comes in and then make your own decision about whether or not there's, well, guilt or not guilt, no guilt? Okay. And then would you commit, I noticed on page 19, you said everyone has a right to their day in court and I'll say to be considered innocent until proven guilty. Okay, so you'll commit to that you won't make a decision about the defendant's guilt unless and until the state meets their burden and actually proves that he's guilty. Is that fair?
Yes.
No, I don't have any more questions.
All right, thank you, Mr. Wixom from the defense.
Just very briefly, ma'am, you had a very strong opinion about media. So I don't think I have any concerns about you listening to anything the media says. Is that fair?
That's fair.
Okay. And quite frankly, you
Use your microphone, Mr. Fryer.
it is on, Judge, and I'm sorry, I'll speak into it. And you were very specific when you said everybody has a right to their day in court, and you underline the proven, which means you're going to make them prove their case, the prosecutors, right?
Absolutely.
Okay, Judge, I have nothing else. Thank you, ma'am, for your time. Thank you.
All right, thank you. I do, I guess, have one question I'll raise in terms of the hardship section. You talked about your position at work, can go on 24/7, and you said I would just work after the court hours. I guess one concern I'd like to talk through with you is if your thinking might continue with full or part-time employment. If you find this to be taking up all of your mental energy and you're not able to work the way you think you would, are you concerned that you might have some hardship if you really can't work while this trial's going?
I wouldn't have a problem with it. My position is, it could probably be done extremely easily, with remote. And I do have backup in other, I'm one of a group in HR, so I'm not restricted to the parts that I'm participating in at work.
Okay. If there were a time that you were sequestered a week, possibly 2 weeks, and you just simply couldn't work at all, would that create any kind of hardship?
Yes.
All right, thank you for just answering those follow-up questions for me. The other topic I want to discuss with you is on your attitudes regarding the death penalty. That's a section that we had you fill out in the questionnaire. Do you recall that?
Yes.
I'll advise you in this case that it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember that any penalty you consider should be done as if it is absolute and will be carried out in this case. You understand that?
Yes.
All right. When you had a choice of do you support or oppose the death penalty, you didn't like the choice of yes or no and circled support, clicked the box, and also wrote depends next to it. And that's fine. This is designed to understand how you think about it. And so it looked like yes or no was not enough description for you. You also checked a choice saying, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. So could you explain, as you sit here, as best you can, your views on the death penalty?
That's my issue, or my choice of answers have more to do with the question. So at the end, when all of the evidence has been shown, then ask me yes or no. I wouldn't want it to be taken out of context.
Okay.
Whether I would agree, yes, death penalty is appropriate, or no, it's not. Because I think it's all situational on the facts of the case, not just an open-ended question.
All right. If you are given specific instructions in this case that say you are to consider the death penalty, would you follow those instructions?
Yes, absolutely.
And if you were given instructions that say you are not to consider the death penalty, would you follow those as well?
Yes, sir.
Are you in favor of the death penalty in every case where a murder's been committed? Okay. Is there anything about your views on the death penalty that would prevent or substantially impair you from serving as a juror in this case and following any instructions the court would give?
No, sir.
All right, thank you. That will conclude the court's voir dire. Does the state have any voir dire questions?
We do not, Your Honor.
No questions, Judge.
All right, thank you, Juror 1382. That will conclude our questioning of you in individual voir dire. I'll have you return with the bailiff to the jury room and we'll give you some more instructions once we talk to the other jurors. Let's next talk to Juror 1436. Okay. All right, juror 1436. All right, juror number 1436 is returned for individual voir dire. We're going to talk to you about the knowledge you have about this case. You do have some. Please openly discuss any facts or details you're asked about. And why don't we start there with the state conducting the voir dire on potential bias.
Okay. Hi. So I have a few questions for you about media exposure. And there's no wrong answers. Obviously, you know, nobody's going to hold anything against you that you saw in the media before you ever knew that you might be called as a juror on this case. So please just feel very comfortable answering these questions. You felt. So it looks from your questionnaire like you did get a decent amount of media exposure in this case. And you indicated that you felt that Mr. Daybell looks guilty according to the news reports.
Well, you know, I didn't see a ton of things and I can't even remember everything now because it was a while ago.
Sure.
But just the way the questionnaire was written, which I forget how it was exactly written, you know, saying, well, if you were to make a decision based on, you know, what you've seen in the reports and everything, then yeah.
Okay. So if you had to make a decision based on what you've seen on the reports, you would feel that he was guilty. Is that what you're saying?
Well, in the questionnaire, the way it asks,
okay.
Just kind of was like, you know, okay, so you were exposed to some media, so I did see some things on the news back then. It wasn't something I followed or anything, but you know, you see it comes on the local news or whatever. So it was like, oh, your perception, you know, they're implying something happened, he's in trouble, you know,
Sure.
So.
Do you mind kind of telling us what you do know about the case from what you saw in the news reports?
Let me think. Just that there was 2 people killed. I didn't know if there were 3, but there were two people killed, that were children. And that, you know, it involved the husband and wife, and that they ran off to Hawaii together. So that was pretty much, and that the bodies were found on one of the properties.
Okay. Did you watch any court proceedings?
No.
Okay.
Didn't watch anything like that.
And it looks like there was a comment in here that you wrote, he may be mentally ill. Do you want to kind of talk about that a little bit?
Well, I forget what the question was.
It was, have you formed any personal opinions whatsoever based on information from any source of Chad Daybell's guilt or innocence?
Yeah, my thought was kind of like if he or she had done something like this, that person would have had to have some problems that would cause them to do that.
Did
So I was trying to answer him honest.
Of course, no, that's great.
So it seems like a blanket statement, but that was the only way I thought I really could answer it on paper like that is, you know, I guess if somebody did something like this, something wasn't right.
Of course, no, and it's great that you answered those questions,
Okay.
honestly. That's exactly why we're all here, and we are all very, very appreciative of your willingness to be so open with us. And just so you know, it's very common for us to ask people who've had media exposure these very specific questions. Did you watch any documentaries about this case?
Oh, no.
Did you go looking for it on TikTok or anything like that? In the questionnaire, you did indicate that you had formed some opinions on Mr. Daybell's guilt based on the media reports, but you indicated that you'd be able to put those opinions out of your mind, which you had heard in the media. Is that still?
Yeah, the way I took kind of the questions being asked, like, okay, you saw so much, this is what you saw. What would your conclusion be from that? So that's kind of what I was answering, but when it came to actually being in a court and making that decision, those things would be put to the side.
Okay,
Ms. Beatty here too, you are going pretty quick, and with this particular juror, I know it's been a real long day for our reporters, so if we can make sure there's no talking at the same time as well.
thank you, Your Honor.
Thank you.
And I'm sorry, not a court reporter. So you're going to be instructed during this trial that Mr. Daybell is entitled to a presumption of innocence. That means that as he sits here right now, and up until the state is finished with its case, he's presumed innocent until we meet our burden of proof.
Right.
Is that something that you'd be comfortable with?
Yes.
And you understand that nothing that you've seen in the news or on TV is evidence?
Yes, I do understand that, yes.
And that evidence is what comes out in court? Testimony, any exhibits, anything like that?
Yes.
Okay. I have no additional questions, Your Honor. Thank you.
All right, thank you, Ms. Beatty. Mr. Pryor.
Good afternoon.
No.
We spoke earlier, but you have your questionnaire with you?
I do.
Okay, let's turn to page 14. Number 2 at the very bottom. Question is, what have you heard or what do you know about defendant Chad Daybell? You see that? You wrote in there on trial for murder of several people. He may have mental issues. And I just want you to clarify, you said that's what you heard and that's what you know. So at the time of this writing, what you know is that he has mental issues?
No, I was just going on based on the news report and things that I've heard about him. Because I mean, obviously, he wasn't on trial. So when I said that, I'm assuming that this person is on trial because of it, and I wasn't following it. So, but I was saying, just like I was telling her earlier, that first, if somebody did commit a crime like this, my initial thought would maybe there were some mental problems.
Okay. And is that still your opinion now?
What?
That Mr. Daybell has mental issues?
No, I was just going by the reports what I had read from the news media, and you were asking me if I could form an opinion from that, that would be the opinion I would form. I don't know if that makes sense.
Then we can go to page 19. Under item number 10G.
Yeah, and
10D. And under 10D, talks about the media exposure, and again, the publicity around the case, whether you formed an opinion of guilt or innocence. And you said yes.
Yeah, I kind of took the question as being, what opinion would you form based on what you've heard about?
And that's fair.
Yeah, so I was kind of giving an answer to, well, this is, oh, sorry.
And when you wrote this at the time, which was, well, several days ago, I guess, right? You said, looks guilty. And you were basing that's your opinion at the time you wrote this, after looking at all of the media and everything that you've been presented, he looks guilty.
Yeah, if you go by what the information I received in the media,
right?
My initial thought is, yeah, the guy's probably guilty.
And that's fair, if that's what you believe. You also believe that at the time that you have to make your judgment, that you have to block out your personal opinion and look at regardless of whether you think he's guilty today or not, right?
Right.
You have to push that off to the side, correct?
Right.
And by pushing that off to the side, you then have to look at this thing and say, I have to be neutral despite the fact that I feel like he's guilty. Are you able to do that?
Yes.
But if we go back, your impression now, and I don't want to put words in your mouth, but the impression now is that, Mr. Daybell looks guilty and I think he's guilty. But if I get chosen for the jury, I will block that opinion of mine that I've already made and I will judge him fairly. Is that where you stand on this?
I'm kind of, I don't know that I believe he's guilty.
Okay.
I just, based on, I kind of took the questionnaire as it's saying, you got this information, what opinion would you form from this information? So that was the opinion form. I don't necessarily believe that he's guilty or not guilty at this point.
Okay. And that's,
But I know I can put that aside.
and surprisingly, that's exactly what I wanted to hear.
Oh.
And you gave me exactly what I wanted to hear. Judge, I have nothing further. Thank you. I appreciate it.
All right, thank you. So juror 1436, then just.
Your Honor, I'm going to move to excuse this juror. I'm going to sort of leave it to the court. I understand that she's saying she could put this aside, but given the depth of media exposure, we do have some residual concerns, Your Honor. So I just wanted to put that in front of the court.
Response from the defense.
Ma'am, I appreciate everything you've done. I don't know, but given the media, Judge, I think that would concur.
All right, there are some comments in there. There is previous exposure. This is a long trial, a complicated case, and as we've seen with many other people, we do have some concern that maybe thoughts and knowledge about where you already are might creep into where we're going in this case. And so you've been very candid with us. We appreciate that. I'm going to sustain the strike made by the state, and with no objection from the defense, juror 1436 is excused based on potential bias, and for that reason, we'll let you go. Thank you for taking all your time to fill out the questionnaire and returning today. I'll have you return your questionnaire to the bailiff, and your jury service is concluded.
Thank you very much.
You're welcome. Next talk to juror number 1503. All right, thank you for returning, juror 1503. We've got some additional follow-up questioning for you based on responses in your questionnaire, as well as indicating today in group voir dire that you have some knowledge about the case. Let's go ahead and allow the state to. There was also some talk of hardship, but let's start off with this knowledge of the case on voir dire. If the state would like to start its voir dire on that issue, you can do that.
Sure. Thank you, Your Honor. Juror 1503, thanks for being here. And again, you've already heard this. There's no right or wrong answers. We just want you to tell us how you see things, how you feel and think about things. And it looks like from your questionnaire, you have seen some media on this case, both from local, national news and internet. What have you seen on this case?
Basically, Yeah, basically just, like I said, a lot of print news, national as well as local. Some of the outcomes of some of the other connected parties, I guess, if you want to say it that way. Yeah, and like I said, just like a lot of news coverage, things that happen in Idaho, you know, whether it's Erie Nations coverage or other type of activities that are high profile stuff, you know, you would read up about those kind of things. So just local interest kind of stuff. So.
Sure. And yeah, no one can hold it against you for wanting to read the news and being informed. You did mention just now, I don't know that it was in your questionnaire, but that you were aware of outcomes in a companion case, and I don't want to put words in your mouth.
Yeah, well, yeah. So in terms of the other people that were involved, like I said, I don't know how.
Well,
I don't know how I just
tell. Oh, sorry about that.
So yeah, I didn't know what was allowed, you know, in terms of details, in terms of that kind of stuff. Going into any more other than, like I said, you know, other people that I guess have gone to court.
Right.
Yeah, just what the outcomes of some of those things are.
And so we're in here just with you individually right now, so that you can be completely candid without worrying about anybody else hearing it. So it sounds like, did you follow the trial of Lori Vallow?
A little bit, but like I said, most of it was the outcome and what was finally handed down, I guess.
And so you know what happened in that case. I want to talk to you about a couple of your answers in the questionnaire. Starting with on page 15, at the very bottom, it says, if you did follow these cases, has that caused you to already form an opinion regarding the guilt or innocence of the defendant in this case? And you said subconscious opinions may have formed. Tell us what you mean by that.
So again, you know, I understand, you know, the presumption of innocence for any defendant. But again, it's hard for you to unknow things, right? And like I said, I can go in with the best intentions and saying, you know, I'm going to go and try to be impartial and do all those kinds of things. But subconsciously, there could be some influence from things that you've known or seen, or kind of things that subconsciously, and that's why I use that word, creep into your judgment or some of your decision-making process at that time. So, like I said, I think I just try to use that phrasing and be as clear as I could.
Yeah.
For that. So.
Being honest about how you feel.
Yeah.
Is it fair to say that while you would do everything you can to set aside what you've heard based on your responses in your questionnaire, you do have some concern that what you have heard could affect your judgment in this case?
Yes, like I said, I brought that out to be as transparent as I can, and saying that again, it's hard to say, hey, I'm going to shut out all the things, because you know some of these things have been going on for years, and that things that we seen things or heard things over the course of years, and you can't just either turn them off or just shut that out. You know, it's kind of almost like a known type of thing in your thought process, I guess. So again, like I said, you know, I would obviously try to do my best in terms of that stuff, but again, that's why I brought up that point to say subconsciously, you know, to try to be as above board as I could in terms of that thought process.
No. Very much appreciate your candor. And it just really quick, it does look like you watched local media, you said CNN, Associated Press, and Reuters on this. Your Honor, we very much appreciate Juror 1503's candor. Based on his answers over the questionnaire in here, we would move to excuse Juror 1503 for cause.
All right, response from the defense?
Judge, I think I have to.
Very well. Juror 1503, this is the process we're going through to try to get the most impartial jury we can, based on knowledge and information you have from a case that would likely affect your views in this case, or at least have the appearance they could. We're concerned. I support the strike and will sustain it. And so thank you very much for taking your time and energy to fill out our questionnaire and return when you were supposed to. Your service as a juror in this case is concluded.
Thank you, Your Honor.
Thank you. . 1537 will be up next. Okay, our next juror we're going to talk to is 1537. Thank you for returning for individual voir dire. I know it's been a long day and afternoon for you. I'll just allow the state if they have any questions on either bias or hardship for this juror.
Now, Your Honor.
You may.
No, who said?
No, I just confirming he's,
Oh,
court is allowing me to go to court.
Yeah, Mr. Whitson, please inquire.
Thank you, Judge. Hello, sir. Again, I just have a few questions about the questionnaire. There's no right or wrong answers. We're just trying to understand your perspective. I do, you have your questionnaire in front of you, sir?
Yeah.
Okay.
Yeah.
May I call your attention to page 8? I'm looking at page 8, paragraph 3, and you were asked a question. Do you feel that the jury should be free to disregard the law given in the jury instructions if they disagree with that law? And then you appear to have checked yes. You then made some side notes, some references to Nazis and remember who else. And I can't remember who else you may have mentioned in there. Could you please just explain the comment?
I think I was referring to also the Fugitive Slave Act back in the day, where if you didn't help someone return to slavery, you could be arrested for it. And I think that would be wrong to do. So I think the jury in that case, and if they were in Nazi Germany, some evil law like that, that should be allowed to disregard.
Okay. So do we take that then, if there's something about the legal instructions that this court gives, if you sit as a juror, hear all the evidence, and then feel like you're put in a place where you feel like it's an unfair law, are you indicating that under your conscience, you wouldn't necessarily follow the instruction or follow the law?
Well, this law that supposedly was broken or accused of breaking isn't an unfair law. And I think it was just referring to it in general. That's how I read that question. So, okay, I think there was certain scenarios where it's okay.
Okay, so you don't anticipate having a problem generally following this court's instructions?
No.
Thank you. And I'm just going down to a quick reference on page 15. You had noted that you were not really familiar with this case and hadn't really followed media, but you did know, I heard of Lori Vallow from the news. Can you just let us know, what is it that you remember about Lori Vallow?
I think what I really remember was when everything was going down, my coworkers back in the day, like maybe 3 years ago, were just saying, whoa, this is a crazy story. And I remember that name. And I think recently she was convicted, possibly.
Do you happen to remember any of the other names that have come up in the case, like the alleged victims' names?
No.
Do you remember where the alleged crimes had occurred, anything like that?
Like Idaho.
Is there anything then about what you have learned from the news that would make you think that you wouldn't still give Mr. Daybell a presumption of innocence, and listen to the evidence and then render an impartial verdict?
Can you say that again?
Is there any reason to think that you won't let him have the presumption of innocence?
No.
Okay, just a last question, and really, if maybe I'm thick, I just want to make sure that I do understand you clearly. If in this case, you are a juror, and the judge gives you a set of what will likely be a large number of different instructions to follow, and that will be what will be the law in this case for the jury to apply. If in any event that any given instruction that you see does not feel fair or right or moral to you, will you still be able to apply that instruction as the judge has given it to you, even if you feel it to be immoral or wrong?
I think I would be able to follow the instructions in this case, yeah.
Thank you. Your Honor, I don't believe I have any more questions.
All right. Okay, no further questions for this juror on those issues then. So juror 1537, there's one other topic I want to go through with you, and that's on the part of your questionnaire called attitudes regarding the death penalty. That's on page 12. Do you remember going through those questions last week and answering them in your questionnaire?
Yeah, yes.
And are your responses there still the same as the way you would feel today?
Yeah, it seems like my answers were basically just kind of, I waffle a lot, so that's accurate.
And that is fine. Part of the way that the questions are designed is to get people to think about it and be accurate in how they feel. So in filling those out, maybe that's more of a thinking about things hypothetically, but here in this case, it may be necessary for you to actually make a determination in regard to the imposition of the death penalty or some other penalty. So when you're thinking about these answers, please consider that it should be done as if it would be absolute and carried out in the case. So you had an answer on, do you oppose or support or oppose the death penalty? You said support, and you said very slight lean, I think. Is that what you were saying?
Yeah.
Okay. You also had a group of 7 choices about what most accurately represents the way you feel about it. You circled part C, which says you generally favor the death penalty, but would base a decision on it. I'm sorry, I'm going to read that. I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that the way you still feel about the death penalty now?
Yeah, yes, sir.
All right. Are you in favor of the death penalty in every case where a murder has been committed?
No.
All right. Finally, is there anything about your views on the death penalty that would prevent or substantially impair your ability to serve as a juror or perform your duty in this case?
I don't believe so, no.
All right, so you would follow court's instructions regardless of whether that was to consider or not consider the death penalty?
Correct.
Very well, thank you for your answers. Does the state have any additional board?
We do not, Your Honor.
Nothing further, Judge.
All right, without further voir dire, then juror 1537, we have one other juror to talk to, and then we'll have you return to the courtroom for more instruction. That will be juror 1577 next. All right, thank you for returning juror number 1577. We've got some additional questions for you outside the presence of the other jurors. State have any voir dire as it relates to any potential bias in this case?
Just briefly, Your Honor.
Go ahead, Ms. Beatty.
Good afternoon, ma'am. Hi. So you had some media exposure in this case, is that correct?
If I did, it was passively. I don't watch the news, so if it was on TV at a restaurant, it was there, but I don't participate in watching the news.
And in your questionnaire, you indicated that you haven't formed any opinion about
No.
Mr. Daybell.
No.
Is that still true?
It is.
Okay, I have no additional questions for
No
this juror.
questions.
All right. All right, there were no further concerns on hardship either, so the court will next address this part of your questionnaire dealing with the death penalty and your attitudes regarding the death penalty. Do you remember going through those questions and answering them in the questionnaire last week?
I do.
Okay, I'm gonna advise you that it may be necessary for you in this case to make a determination in regard to the imposition of the death penalty or some other penalty. Remember that any penalty you consider should be done as if it is absolute and will be carried out in this case. Do you understand that?
I do.
All right. In your questionnaire, when you were asked if you support or oppose the death penalty, you said you support it. Is that still the way you feel today?
Yes.
In addition, when given a range of choices about what most accurately represents the way you feel, you selected an option that reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the way you feel about the death penalty as well?
Yes.
All right, so to be clear, that part that says you would follow instructions in the case, you would be willing to do that?
Yes.
Do you favor the death penalty in every case where a murder has been committed?
No.
Okay, is there anything about your views on the death penalty you haven't mentioned that you think would substantially impair or prevent you from serving as a juror in this case and following instructions relating to the death penalty?
No.
All right, that concludes the court's voir dire for this juror. Does the state have any voir dire?
No, thank you, Your Honor.
That's okay. All right, thank you, counsel. Juror number 1577, if you'll return to the jury room with the bailiff, we'll have you back here shortly. Counsel, could I have a quick sidebar with you before we bring the jurors back in and adjourn for the day? Thank you. Please be seated. We're gonna have this jury panel then brought in for passing for cause. If you could instruct the marshals, please have the ready name jurors brought back.
Judge?
Yes.
Council approach briefly.
Yes. Thank you. Please be seated. All right, we're going to take a final inventory of the remaining jurors here to match against our seating charts. If you wouldn't mind, please hold up your red cards and we'll take our notes. Okay, thank you. I'll inquire of the state now, and we are back on the record in the case here. Does the state pass this remaining small group for cause?
Yes, Your Honor, thank you.
Does the defense pass this small group for cause?
Yes, Your Honor.
All right, thank you, counsel. Ladies and gentlemen of the jury, you've now been passed for cause. We're going to continue on with our proceedings and have you contact our jury commissioner, Randy Rutland, on your way out, who will give you further instructions regarding when you will return. While you're waiting, please don't do anything to investigate the case, look up the case. If you see the case passively in media, please try to avoid any exposure to that so you can remain impartial in the case. And don't discuss the case amongst yourselves or with anyone else. However, you are permitted to discuss the fact that you may be serving as jurors with family, friends, employers, etc., to make arrangements, but don't engage in any discussion about the case or the facts. We will be asking you to sign an affirmation coming back that you have followed that instruction. So with that, that will conclude our juror selection for today. Does the state have anything further before we adjourn?
No, Your Honor, thank you.
Anything further from the defense?
No, Your Honor.
All right, thank you. Counsel will be adjourned until tomorrow. All right. Okay, thank you. We'll see everyone tomorrow.